Morning. Call the meeting of the Texas Real Estate Commission to order on February the 12th, 2018 at really 10 o'clock. The clock in the back of the room is not working, so do not be paying attention to it for time, because we would be a lot early if we were going with that. Appreciate the crowd. It's clearly obvious that the trade association has a meeting in town, because many of you are here attending that meeting, and we appreciate you coming. Remember, if you want CE credit, there is paperwork you have to do in the back. And if any of you in attendance wish to speak on any agenda item, you need to fill out a piece of paper, give it to the two lovely ladies here, and they will make sure that I get it so I can call on you to speak when the time comes. So if you are here to speak on any agenda item, I need a piece of paper. And I certainly thank Abby Lee, attorney for the Texas Association of Realtors, for being in attendance today. And we have a new liaison from the governor's office that I haven't seen yet, but I thought was supposed to be here, Katerina Gonzalez. If you slipped in and I didn't see you, apparently not. Okay. So we are going to all rise and have the pledges of allegiance. Mr. Leonard, would you lead us?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Honor the Texas flag. I pledge allegiance to thee, Texas, one state, under God, one and indivisible.
You may be seated. I need a motion to accept the absence of Commissioner Turner, who was can't be here today. Second?
Second.
All in favor, say aye. Opposed, no. Motion carries. He is excused. It's now the time that we do every year, elect a vice chair and a secretary. So if there are any nominations for vice chair, I would hear them now.
Madam Chair?
Yes.
I'd like to renominate our current vice chair, Commissioner Adrian Arriaga, for vice chair.
Okay. Are there any other nominations for vice chairman?
I'm Commissioner Williams, and I've
So is that a motion to put his name in? Okay. So I think I kind of flubbed this up last time when I had two people. Do I just ask for a hand vote for each, and whoever gets the most votes is the way it goes? Okay, so I would call them in the name they were nominated. So everyone who wants to vote for Commissioner Arriaga, please show me your hands. 1, 2, 3, 4. And Commissioner Leonard? Who would be for Commissioner Leonard? Okay. Okay. So, Commissioner Arriaga, I believe you're still going to stay in the chair.
Thank you, Madam
Thank you. Secretary Treasurer, do we have any nominations for Secretary Treasurer? TJ is
Can we vote
Secretary.
in absentia?
Secretary, not Treasurer.
Can
You're
we
right.
vote in absentia?
Yes, if somebody's not here, we
I'd
can
like
vote
to nominate Commissioner TJ Turner.
Okay. Are there any other nominations for Secretary? I guess the word is out on how much work that is. So everybody who's in favor of TJ for secretary, raise your hand. Okay, we got that out of the way. I have some appointments that I intend to make at this moment. Let me see if I can get my piece of paper in front of me so I don't mess that up. I was going to ask the same people if they would to continue serving on the Enforcement Committee, which would be Commissioner Turner as chairman and Commissioner Arriaga and Commissioner Leonard to serve as well. And on the Budget Committee, I was looking for I can't chart Westcott. Yeah, I can remember your last name, Commissioner Westcott. Our new commissioner from the Dallas area, Commissioner Williams, and Commissioner Stevens, are you interested in being on the Budget Committee? I had you down?
Yes, ma'am.
Okay. So that would be on the Budget Committee. Our liaison to the Inspector Committee, Commissioner Arriaga, are you willing to do that?
Yes, ma'am.
Okay. And our liaison to the Education Standards Advisory Committee, Commissioner Wilkinson, are you willing to do that? And our liaison to the Texas A&M Research Center will be Jan Fight Miller. And then we're going to, as we talked about last time, appoint a broker responsibility committee. I was going to read their charge into the record. We're going to ask them to review both education and experience for brokers' license requirements to see if we can have more relevant and transactional experience both in years and transactions to offset a portion of the required education. Should we look at agency managerial experience? Should we look at relevant military experience? Or are there any other alternatives of experience that could be looked at to get a broker's license? To look at minimum competence requirements, can we define any basic training requirements for broker-sponsored agents to assist with ensuring minimum competence? To look at perhaps a broker-to-broker mentorship program where they would review and make recommendations about minimum standards for mentors and appropriate use of this alternative role. Look at a broker's role in potential award and maintenance of TREC specialty certifications as we move in that direction from the education standards and the processes for both. To determine if there are additional steps that need to be taken to make sure that fee-for-service brokers are meeting the minimum statutory requirements, and look at temporary out-of-state practice registrations for real estate brokers in commercial transactions. It's kind of a big charge. We seem to think they can get that done in about 3 meetings. And on that committee, looking only at brokers who have or are still sponsoring salespeople, also to worked hard to get a broad geographic range of brokers, as well as people operating small companies and medium-sized companies and large companies, 9 people. Marilyn Gibbs from Lakeway, Texas, Nancy Herzig from Houston, Texas, Gayla Skates from Houston, Texas, Jessica Craig from Arlington, Bob Baker from Plano, Bob Jacobs from San Antonio, Kelly Gonzalez from Laredo, Bill Evans from Austin, and Bill Jones from Temple, Texas as chairman. And I think some of those people are in the room. So if I called your name just now and you're in the room, would you stand up so the other commissioners can see you? So there you go.
Thank you.
I appreciate that, and now I would tell you that I'm guessing on 3 meetings, so it could be more now that it's done. I think it's the time in our meeting where we have our staff and
Madam
committee
Chair.
reports. Yes, sir.
Regarding appointments, and as you know, I've been around for a little while. I think I'm serving my 11th year. And someone brought it up to me. All the committees are important, but the question was made, and maybe you need to consider, would want to consider for the next year or so, moving members to different committees. In other words, don't appoint someone for the life of the term to that committee, but rotate them. That way, everybody can be exposed to different areas that are occurring and be able to get wisdom from all the committees. So, with all due respect,
You're talking about commissioners?
commissioners for the committees we just
Okay.
appointed.
Well, we
rotate 'em.
we actually just did that.
Correct, but
Yeah.
sometimes we keep them there for a long time. If you can just make them, change them every year to someone else.
We could,
And do we have a committee for the building committee?
yeah, you're on it, aren't you?
We do. In fact, and that, if you want to just reiterate that, we have 2 members, and I'm going to give a report later on in the meeting, an update, but we have 2 members from the commission that are part of the long-term strategic facilities plan, and that is Commissioner Arriaga and Commissioner Westcott.
Because, well, we didn't have a meeting this past year, did we?
We did not.
I'd like to have more meetings if we could for that committee. Thank you, Madam Chair.
We have that on record, that he wants more meetings. I don't know if you got that. So now we're going to have reports from the staff and committee, and I believe, Mr. Olmixon, you're first.
Good morning, Commissioners, and welcome to your regular quarterly meeting, and thank you for your continued service. We distributed today new name tags that you can use whenever you represent the agency at any function. I know that you all know each other, but not necessarily when you're out do others know that you are a commissioner, and so we thought that might be helpful. And also, you'll notice that agency staff also has name tags. So when you're interacting with them, you also have that advantage of knowing that they're members of the staff and their names. So we hope you enjoy them. If you lose yours for any reason, just let us know, and we will order you a replacement. Remember that this meeting is being broadcast live on the web, and it will be archived there when it is completed. And this is the annual meeting at which your February quarterly meeting, that CE credit is available for those who register, hold licenses, register, and stay for the entire meeting, up to 4 hours of continuing education credit. There are several current issues that we face and would like to emphasize. First, this is our year for both strategic planning and for rule review. So we will be discussing opportunities to remove any identified barriers and reduce red tape that hinders or slows the licensing process without providing a clear and commensurate level of consumer protections. In other words, we're always looking for ways to reduce regulations, to maintain and promote free markets while balancing the legitimate needs and expectations of consumers to receive the highly professional and ethical service from the real estate-related license holders that they contract with and that we regulate. How well we accomplish this, our mission, will also be more closely examined as we undergo sunset review this year. At the TAR winter meeting this weekend, we shared some insights on the upcoming changes to the advertising rules as a part of the risk reduction panel on Saturday. Another 2-hour session educating its members on these updated rules is planned for this afternoon from 3 to 5. At the commission meeting today, we will consider whether the extent of the impact of one adopted change warrants your reconsideration. And that'll be in agenda item 23A. We will announce the strategic planning listening tour and introduce some of the key issues under discussion during this process. The broker responsibility working group has been appointed and will begin exploring how to strengthen the consumer experience and potentially add desirable options and flexibility on the path to licensure. The Education Standards Advisory Committee is considering strengthening the critical focus on the use of our promulgated contracts in continuing education, and also exploring the potential options for appropriate voluntary certification in focused practice areas, beginning with residential property management. You'll hear more about that as well. The practice of real estate brokerage continues to evolve as technology provides both opportunities to enhance service to clients and challenges to ensure legal and ethical requirements are honored. Both convenience and expertise can be enhanced if careful attention is paid to the fundamental principles underlying this profession. We invite all stakeholders to share their ideas, inform, and assist the Commission as it carries out this important mission. New this year, during our strategic planning, will be online town hall sessions to serve those who cannot come to a live event. and plan to join us for the second annual Texas Residential Realty Summit here in Austin on April 2nd to earn up to 5 hours of continuing education while exploring the impact of natural disasters on the residential realty market. Some details are found in our advisor newsletter we published last week, and more will be distributed soon. Last week, the appraisal subcommittee was in town and examined the Texas Appraiser Licensing and Certification Board. They were here from Tuesday through Friday and gave a very positive report to the board on Friday. We expect to get a written version of that report within the next 3 weeks. Also on last Thursday, the agency was recognized by the State Employee Charitable Campaign with 2 awards. Out of 90 state agencies participating, this agency was recognized for the highest percentage participation among the staff, over 90%, and for the highest average per capita gift, over $240. We're very proud of our team's dedication to this charitable effort. Thank you, as always, for the guidance you provide on all that the staff is charged to do. Unless you have any questions for me, I'll invite the rest of the team to provide their reports and updates. Any questions for me?
I do.
Yes, ma'am.
I was noticing the agency strategic planning tour
Yes.
that is being announced.
Yes,
Who put this together, sir?
the staff did.
I noticed that San Antonio, Houston, Austin are missing. I know we cannot cover them all, but these are some of the most important cities in terms of number of licensees that we have. Is there a way that we could include them?
So we try to balance every one of those markets with a nearby market every other year or every other time we do strategic planning. So while we won't be in Houston this time, we'll be in Galveston instead. And we've done that in prior years, Dallas and Fort Worth kind of thing, Austin and San Antonio. In this case, we'll be in College Station. What I would say is that we'll have the online town halls available. So this will be a first time that we do that. We're going to do 2 of those during the month, and so that will be an opportunity for someone, if they can't make it to a nearby location, to participate. Any other questions? All right. Thank you, Commissioners.
Ms. DeAnda?
Good morning, Lori DeAnda, Director of Reception and Communication Services. I'm happy to begin with informing you that RCS is fully staffed, so I am introducing our new 3 team members. First is Stephanie Green. She began her employment with the agency as a customer service representative on January 2nd. Ms. Green was employed by TREC in 2004. She moved to Houston, Texas, and was employed with the Harris County Transit Authority, where she worked as a police dispatcher. She's returning to TREC due to being affected by Hurricane Harvey. Stephanie is a quick learner and is motivated and willing to assist everyone. She remembered the information from the past, so she simply needed to be updated on the changes. She has been fully trained and is able to answer calls on her own. She has over 15 years experience in the customer service field and outside of work. She loves being a wife of 5 years and a mother of 4 girls. She is excited and grateful for the opportunity to rejoin our team. Please help me welcome Ms. Green. Our next new team member is Lahonia Young. Ms. Young began her employment on January 2nd as a customer service representative after over 10 years in the dental community. She served in the United States Navy aboard the USS Dwight D. Eisenhower during 9/11 and 1 deployment overseas. While serving, she received the Navy E Ribbon, Good Conduct Medal, National Defense Service Medal, Armed Forces Expeditionary Medal, and the Sea Service Deployment Ribbon. LaHonia, a Paris, Texas native, has been married for 14 years, and they have a 13-year-old son, Patrick, and their dog, Rocky, who they love. LaHonia enjoys spending time with her family, shopping, and working out. LaHonia is very excited with her position with the agency, so please help me welcome Ms. Young. Our next team member is Christy Grimberg. Christy transferred from the Education and Licensing Services Division to RCS on January 29th. She began working for TREC and TLCB in September 2010 in the ELS division. In ELS, she had many roles, which included processing applications for real estate agents, brokers, appraisers, providers, and instructors, as well as processing education. She has been married for 26 years, is a proud mother of 1 daughter and 2 sons. She is a doting Nana to her 5-year-old grandson, and she enjoys spending time with her family and doing arts and crafts. Please help me welcome Ms. Grimberg. Please refer to the C1 report. In the month of December 2017, we received 18,763 calls. We assisted 207 walk-ins and responded to 7,717 emails. The next report is a C2 report. In the month of December, we received 30 customer service surveys. 11 surveys included comments and contact information. The top 3 categories with the most comments were in regards to the hold time, customer service, and application processing. And of the 11 surveys, they were all resolved. The next report is a C3 report. The report contains the information per quarter. So this information is for September through November 2017. The average hold time is 15 minutes, and the average length of the call is 5 minutes and 15 seconds. Now, before I conclude my report, I have some information I would like to share with you. From the last commission meeting, some concerns were mentioned that some of you were receiving calls with comments on the complexity of reaching someone for assistance. To help eliminate the calls that are directed to you, a couple of items have been implemented to help resolve these calls. Item number 1 is in January 2017, the licensing email box was forwarded to the information email box that escalated the email volume. Some of the emails that RCS received were emails that pertained to documents that needed to be forwarded to ELS for processing. To prevent RCS from spending time in forwarding emails, a new email box has been developed for documents to be sent straight to ELS for processing. The new email address is documents@trec.texas.gov. This feature shall allow RCS the time to respond to questions and provide assistance. Item number 2 is the processing status dates of the broker and sales agent applications and renewals, which have been posted on the TREC website. The page includes the processing dates and where to submit the documents. This page went live on the website on January 31st. And this concludes my report. Does anyone have any questions?
Yes, is this on? Can't tell. Is it on now? On the emails, where will the membership, where would they see that address?
It's already on the website, and when we are responding to emails, we're notifying the stakeholders on where to submit the documents.
Madam Chair, I spoke to Ms. Deanda earlier today, and thank you so much for taking that step forward and doing something. But the biggest, the only concerns calls I get is about waiting, cannot get access. And I requested, I think it was a couple of months ago, Mr. Olmixon, that wanted to see the trends. How was it last year? And I think I requested the last 5 years. Mm-hmm. Are we getting worse, or is it getting better?
Just a second, I can give you some information on that. Okay, so for the last 5 years, the most comments that we received had to do with the website. And from reading some of the comments, there's 2 sections of the website. One has to do with, since the website went live in February, which was just this past fiscal year, some of the information that we are receiving has to do with the lack of information that's no longer on the website. But the majority of it has to do with the online accounts. Some people are having problems with their passwords and having difficulty with logging in. That seems to be the main concern.
It's so personal when people are scrambling for information, and I went through it. Someone in my office called, and he would not talk to me because he knew I was going to make a phone call, and he waited a couple of days before he got in. I think we had some technical problems also. The system was down there for a while. And I know we're trying real hard, but that's the only way that I think we should be evaluated as commissioners. And if they're going to complain because they cannot get in, a simple step, we're a little bit far behind, Ms. Dolmixon. So we need to try a little bit harder. And I'm hoping this new link you're going to send me works. So I'll check into it today.
And I think it's just a matter of time, but I do believe that it will be very beneficial in lowering the call volume. Because some of the calls that we do receive have to do with checking the status of their applications. So if they go to the website and they see what the processing date is, they'll know whether if it's time to contact us for that information or not.
If you can be so kind, send me what you have for the past 5 years that I requested a couple of months ago.
Okay.
I want to see the trend, and then let's review it next time we meet. Thank you so much.
Any other questions?
I just have a comment. I think this is great that we are moving towards improving this, but we're not really solving the problem, just, giving that option. I think that we need to be able to have access, because we're enforcing so many things that if people have questions and they need to talk with somebody because they are not, they don't have internet available, that they can also contact someone. We always prefer personal service, just like the service we provide. So I strongly encourage the agency to continue striving to serve personally. Thank you.
Thank you.
Thank you, Ms. Deanda.
You're
Ms.
welcome.
Jackson?
Madam Chair, Commissioners, good morning. Gwen Jackson, Director of Education and Licensing Services. The first report before you for the ELS division is the L1 report, and this report provides the December fiscal year-to-date totals and comparisons for applications received, licenses issued from applications, as well as renewal activity. The column to your far right provides the percentage of change for each line item that's listed. There are no significant increases or decreases in our comparative totals as we continue to receive a consistent flow of applications from which we issue licenses. Our renewal activity indicates that 18,034 brokers and sales agents renewed their licenses during this period, and that over 78% of those who were eligible to renew did so. The next report before you is the L1A report, and this report provides the same type of information for the inspector program as the L1 does for brokers and sales agents. There is a 13.8% increase in total original applications received, or 37 more than we had in December 2016. There is no significant increase or decrease in the other categories. Our renewal activity indicates that 226 inspectors renewed their licenses during this period, and that 66.8% of those who were eligible to renew did so. The next report before you is the L2 report. And the L2 report provides totals of our license holders and registrants, as well as a snapshot of our totals for each month of the previous year. You can see how busy the agency continues to be, as our total number of brokers went from 44,813 in December 2016. As you can see to the far left, there's a column entitled December 16. And then to the far right is our December 2017 totals. so that you'll see that it went from 44,813 to 45,337, which is an increase of 524. Also, you'll see that sales agents went from 126,741 to 135,639, which is an increase of 8,888. During this period, we increased our number of brokers and sales agents by 9,412. We also saw a modest increase in real estate inspectors from 3,642 to 4,060, which is an increase of 418. Our overall total license holders and registrants went from 177,207 in December of 2016 to 187,046 by December of 2017, for a total increase of 9,839. The next report in your package should be the L3 report. And this report provides a comparison of our fiscal year-to-date examination activity for our real estate license holders as well as our inspectors. The top portion of this report is for real estate, and the bottom portion of the report shows the statistics for our inspectors. And with your permission, I'd like to summarize this report for you. As you'll see in the far left corner, in the far left column under sales agent, 11,189 examinations were taken in 2017. 485 broker examinations were taken. The first attempt pass rates for our sales agents was at 48.4%, and for our brokers was 55.7%. So you see that we remain consistent with our sales agents from 2016 to 2017 at roughly 48%. And then we see an increase in first-time pass rates for our real estate brokers from 49.3% in 2016 to 55.7%. Now, if you'll move your attention to the lower half of the form of the report, you'll see that real estate inspectors, 21 examinations were taken from September to December 2017. 421 professional inspector examinations were taken. If you'll move down to the last line item, you'll see that the first attempt pass rate for our real estate inspectors was at 33.3%, which is consistent, roughly consistent with what it was in 2016. Our professional inspector first attempt pass rate was 46.7%, and in 2016 it was 42.5%. So you see a slight increase there. In moving to the next report, it's our L4 report, and it provides the number of approved instructors for our real estate and inspector courses. Our totals as of December are reflected in the far right column. The bottom portion of this report provides our inspector-instructor totals. Are there any questions for any of the reports I've given you?
Any questions for Ms. Jackson?
I have one question. You handled 10,000 more applications.
Yes, ma'am.
Did you all hire any other employees?
Well, yes, we've hired in the ELS division. We've hired one extra team member, and we're currently working to ramp that up because yes, we have seen a consistent increase. We've had some vacancies, and then we filled positions as well, but we're trying to keep up.
Is the hiring freeze off?
Yes.
Okay. Thank you, Ms. Jackson. Mr. Moore?
Mark Moore, Standards and Enforcement Services. I've got 3 reports. Before I start the reports, we do have 2 new employees. The first is lawyer Ken Herring, who should be standing up by now. Mr. Herring came to us from the Department of Motor Vehicles and the Department of Public Safety. He has an extensive administrative law background, and we're happy to have him. The second person is Ashley Fletcher, who is probably also standing. She's been with the agency for about 4 years, 3 or 4 years, and she's going to help us in our background history processing as a program specialist. She starts on February 20th, so she'll continue her licensing duties until the 20th, and we're also very happy to have her as well. The reason we're happy to have these new employees is just in general we're happy to have help like that, but if you look at the report, the case status report, there is a bold row received during month. We had incredibly large numbers in the first 2 months of this fiscal year. The next 2 months we had 350, which is a significant drop. Historically, those 350 numbers are actually quite large, but compared to those previous 2 months, it's actually a relief for the division, and it's helping us a little bit. If you look at the next sort of bold row that closed during the month, our productivity has been very high, so we've been able to keep up with all these new cases, and they've been able to close more than we've opened for the year. So these present a lot of challenges, but we're making some progress on that. In the next report, the case aging report, that also shows how old these cases are, so how quickly are we processing them. About 98% of the cases are less than a year old, and then there's a number of older cases. Those are typically cases that are contested cases, and the very oldest cases are always involved with the SOA process, which is the State Office of Administrative Hearings. So once it goes into that process, we don't have much control over the timing because of continuances and settings and time to do decisions on that, but in general, this report is good. The third report is the complaint subject categories report, and this is a pie chart that kind of shows the general types of cases that we're processing. These are mainly the real estate cases, although it does include some of the background history cases if they result in an order or disapproval. The pie chart gives you a graphics picture, and then the next page gives you the raw numbers as well on this. Do y'all have any questions on this report or any of the other two reports?
See none? Thank you, Mr. Moore. Mr. Spiropoulos.
Wow, you got good at that.
I'm getting better.
Thank you. Good morning. Steve Spiropoulos, Director of Information and Technology Services Division for TREC. And so for today, I'm going to be going through two reports, the I-1 and the I-2. Before you have the I-1 report, which shows us the utilization of our online applications as well as the number of visits to our website. So compared to last fiscal year to date, we had an increase from above 11 million last fiscal year to date to over 13 million this fiscal year to date for the website pages viewed. And then for the online transactions, if you look at applications that are taking place online, we had a jump from 82.2% to 91.6% for the fiscal year to date comparison. The renewals stayed about the same at 97%, and then for the sponsorship transactions, we've seen an increase as well from 89% in the past to 95% online today. Report I-2 is the graphical representation of I-1 taken over time. And so for the utilization of application services, we've seen an increase, and it has stayed steady at above 80%. Or above 90% actually for the last couple of months on the reporting period, so that's November and December. For renewals, it's pretty steady, up and above 95%. The last month reported was 97.1. And then for the utilization of the online relationship management tool, we are steady at above 90%, almost 95% for the last month reported. And that's the conclusion of my two reports. Does anybody have any questions? Yes.
Steve, it looks like the last couple of months, maybe 3 months, we've experiencing some technical difficulties. Are you also in charge of that part of the tech?
Yes. all of the technical difficulty issues that take place, if they are really technical in nature, they go through my division for processing, and then we will address the problem. There are, I would say, 3 categories of problems. The first category is a small issue that happened once that we can resolve rather quickly. The second category is something that involves making a change to the system, or perhaps involving a vendor to fix an issue. That turnaround time is usually medium, so a week, 2 weeks, 3 weeks, maximum about a month. And then the third category would be large problems that are system-wide problems that take longer to resolve and may even result in the need for replacing a system, for example. So that's how we look at the problem categorization.
That's going to be the question. How old is our system?
Depends on which system you're talking about. We have many different systems that do many different things. One of the systems that we use, and that's the one to renew licenses, make changes to your license record, that system has been in place and live since the year 2010, September.
But the latest version of it was upgraded in November of 2016, correct?
Yes.
Did we finally complete all the scanning of the information completely?
Yes.
So we're all up to par on
So
that.
the scanning project completed about a year and 2 months ago, and now we are scanning regular incoming mail. And so we have a staff that there's no longer a backlog of paper files that sit to be scanned. Everything gets scanned as it comes in. And so we're now no longer needing to store the large amount of documents that we stored in the past.
So you have enough money in the budget to carry this for the next 2-3 years in terms of technology, is that correct?
Yes, actually, we're going through budget review this week, and so we're going to be looking at those numbers very carefully.
Thank you, Madam Chair.
I have one question.
Yes.
Would you need increased staff, or is it just the technology? And are you outsourcing any of the services to handle some of the issues?
Great question. So in terms of staffing and outsourcing, right now there's a balance. A portion of the work is outsourced. A portion of the work is being done by vendors who have a maintenance contract with us. And then for the work that's done internally, we are looking at how much work do we have and do we need to expand our team actually right now. So there's a tremendous amount of data that is being gathered about everything that we deal with. We're going to do some analytics and look and see how many hours we spend on projects and on day-to-day tickets, and then determine if we need to hire more staff.
Well, what's your time frame in finding it out before the budgets are set?
Yes, it's probably within the next couple of months for sure. Yeah.
Any other questions?
Thank you.
Steve? Ms. Pifo?
Good morning. I'm Priscilla Pifo, Director of Staff and Support Services. My division is over accounting and budget and human resources. My first report for you is the budget status report for December, 4 months into the fiscal year, so we expect to have about 66.67% remaining. And you'll see that in the far right column is the target that we'll be looking for. We're consistent with that for both expenditures and revenues. We generally will add notes to items if there's some kind of exception to that rule. So you'll see those notes there, and if you have any questions, please let me know. You may recall that in the last time when we met, we had a discussion about a reallocation of money for the State Office of Administrative Hearings, and you'll be asked to ratify that change to the budget later on agenda number 24. And if you have no questions on the budget, I will move on to the investment reports. So I'd like to draw your attention to the first one, which is S1A. And typically I'm going to be focusing on the ending market value, which is the fourth from the right column. And you'll see that our total number of investments for this operating account is $11.871,747,000. You'll notice on the far right the maturity dates, and that again is our laddered approach to investments. We had one that became mature during this period. We increased the amount of investments by about $400,000, and that is included in the total that we have. We maintain a 3-month reserve in cash, which is the ending balance of about $3.5 million. Our goal is to invest in amounts in excess of what we need for that daily operations. If you'll move on to the S2 report. This is the trust account for the real estate recovery account. We also had one note that was matured in December. We invested it. The ending market value is $1,894,205,000. And you'll notice that we have a set aside, and if you'll go to the next screen, please, of $699,555 for potential payments for the next 3 months. And this particular chart, if you'll scroll down just a little bit, please, up, other way. This shows the total payments over time and the sources. Moving on then to the S3 report. This is the recovery fund for real estate inspections. And you'll notice that the total amount is just over $615,000. At the end of the calendar year, by statute, we are required to take any monies in excess, including cash, in this account into the general revenue fund. And we have done that, and you will see that in your next report. I want to give you a brief update on a couple of other things. One is our internal audits. I don't have reports for these, but I'll just give you a quick update. We have an internal audit, as you were told at the last meeting, where they were going to be conducting an internal audit of human resources, and they are in the process of doing that. Mainly they're looking at in regards to staff compensation and engagement. We've received some initial feedback, and we will be reporting on this in the next meeting. We've also had an audit. We've just been fortunate to have lots of audits lately. Is the Texas Workforce Commission has done the EEOC audit, which is a 6-year review to make sure that we are fully in compliance, and we have just completed that. And I'm also happy to report that we have updated, and Chairman Arriaga, I believe it was you who had asked us about alternative methods for payment, and the ability to do electronic checks, or ACH, is being tested, and it should be in full production by next week. If there are no questions. That's great. Thank you so much.
Ms. Lewis, are you making the report for the Enforcement Committee in the absence of the chairman?
Yes. And I'm just going to note that there was a meeting in early January to hear a motion for rehearing. That motion was granted, and that item is before you today on agenda item 11.
Okay. I believe Chairman Jones is here from the Education Standards Advisory Committee to make a report for this committee. Thank you.
Good morning. I have to do this on my iPad because the print was so small when I got it that I couldn't read it. So give me just 1 second to get that up. The Education Standards Advisory Committee met in January for our first meeting of this year. And we had a packed house for our meeting, and we also welcomed our 6 new members who were attending for the first time. They had a little class before we started our meeting to kind of bring them up to date and give them some instructions on open meetings and things of that nature, so that was helpful. I'd like to first publicly thank our new members for their willingness to join our committee and work on these important issues with us, and we hope that we have them up to speed very soon. I'd like to inform you that I was reelected as chair of the committee, and Diane McCoy was elected as our vice chair, and she is in the audience today. We are both honored to be trusted with this position and look forward to getting to work this year.
Hold on, Diane, stand up so everybody can see you. There you go.
So the first thing that the committee did was to discuss the development of a certification program for property management. And I brought this to you at the last meeting just to say that we were going to work on it. Well, we did work seriously on it this time. However, we are not proposing it to you today because we decided that it would be good for it to go out on the talking points with the around the state and get something from the stakeholders on that before we did that. But after lengthy discussion relating to how the program would be established and maintained, the committee voted to proceed with this is a voluntary property management specialty certification, very much like what lawyers would get for board certified. We will not be providing the education for it. It will come from other sources that already have property management things. That was one of the questions at the last meeting. So let me assure you that we are not creating the coursework that will be done from this. There's many other places to get it. The certification will not be a requirement to be able to practice property management. So there is no restriction on you having to get this before you can practice. It is just a way of reassuring the public that this certification says that you have done extra and that you have more experience. And so anyway, that's the way that's going to work. There will be experience and examination requirements for this certification, and I'm really not going to go into all the details of what that is yet because we don't have it set yet. We have suggestions, and we're hoping for more suggestions, and then we will work on that more at our next meeting. We are going to do this as we think, a two-path way. What we began to see is that we've got a lot of people that have been doing property management for many, many, many years. And then we have others that might want to get this certification that don't really have as much experience. And so there will be two different categories of that but based on experience. And we'll do that kind of like the broker, what is that called? That sliding scale that you... The broker experience points. We'll do it somewhat like that. And so those who have more experience will be able to do a little bit less than what the ones that have less experience will do. That's how we're looking at it right now. So as I said, we're going to wait for the executive director to bring us back some ideas from the strategic planning listening tour in March. We will be reviewing a proposed program online, as well as considering possibilities for a similar farm and ranch certification at our next meeting, which will be in April. The other thing that we discussed at our last meeting was the possibility of increasing the required continuing education hours per renewal period from 18 hours to 21 hours. After a great discussion, the committee agreed to recommend the increased hours. The purpose of the proposed increase is to add 6 hours of CE for contracts, which could be met by taking one or more TREC-approved CE courses dealing with contracts. As currently recommended, the choice of the courses will be up to the license holder. In order to allow input from stakeholders, the committee has also asked the executive director to include this recommendation on that tour in March. We look forward to hearing the feedback we receive on these recommendations from the strategic planning tour and continuing the mission of improving education standards for license holders. Our next meeting is set for April the 9th at 10 o'clock here in Austin. And this concludes my report. I'm available for any questions you might have.
Just have a comment.
Mm-hmm.
When you all are considering... Thank you, Madam Chair. The giving points for the folks that are trying to get alternative ways to get their licenses, since they're to prevent that there are so many in the industry that are related, and that the measure is objective when that happens, so that it doesn't matter whether you work for your dad or for your mom, that everyone that is attempting to do this, that is going to have to do the same thing in terms of experience. That's so when you're thinking about what to do, please, perhaps you can consider that. Thank you.
Okay, thank you very much. Any other questions?
Right here.
Yes.
Are you also going to look at commercial competence?
We do have that on our radar, but we're going to get the easier ones done first. And nothing is easy, but I mean, I think that one might take a little bit more. None of us who are on that committee really do that much commercial stuff, and so we'll probably have to call in someone to give us a little bit of advice on that. So,
Don't we know who that could be?
I'm also concerned about, I'm in a big city, so you can kind of specialize. But somebody in a more rural area, they've been doing this for possibly generations, handling farm and ranch, handling property management and commercial. So to me, it's going to be very difficult to compare those points that we're using now for brokerage. Just be careful.
renting a house anywhere, or, I mean, we're not talking about commercial leasing at all. We're talking about residential right now.
I understand. I just know that
Yeah.
when you start classifying people, and it may be different selling a local washateria in,
Which would be commercial.
which would be
Right,
commercial.
Right, and
But-
that's why we're kind of pushing that one back for a while. Because we want to make sure we get all the kinks out doing this residential one, which really, residential should be fairly the same, whether you're in the country or whether you're in Dallas. And you're right, the ones that are farther out have probably been doing it for 40 years, like my husband has. And so we will, that's why we want to have the two different tracks for getting this, because, go ahead.
I think the fear that I've heard were from farm and land people, so I know that's also on
We
that
haven't even talked
radar.
about that one yet, so I don't know why they're scared of us yet.
It's already it's already out there in the weeds.
Yeah, we have not even discussed that one, so I don't know where that's going to go yet.
You got the question?
Madam Chair, apparently the word got out that we were going to increase our continuing ed, and the question was asked, who decides, in this case, how is that decided? And when was the last time we decided that we needed more education as time goes on? And at what point is too much too much?
You're asking the wrong person that question, because I'm an education junkie. I believe that the reason that we wanted to raise it was to make sure that everyone got contracts. We get more complaints and concerns over people not knowing how to do contracts correctly, from brokers, from complaints and all that kind of thing. So the reason for upping it was to get those 6 hours in and still give them choices for the things that they would also like to take as CE.
Makes a lot of sense. The only concern was that maybe we're increasing it because instructors want to be able to provide more education classes.
Instructors had no, I did not hear a single input from any instructor in that room.
Correct. But still, that's the expectations out in the field. And you can only spoon feed people so much. It's a broker responsibility that when they write a contract, they got to review it and make sure it gets done. Works on the commercial side. I'm sure works on the residential side also. Too much education is not going to make them sane on how to do a contract.
I believe it will. I believe it will help them. If there's many residential
Practitioners.
franchises or just individual owners that the broker does not educate their people. We see it all the time in our small market. Now, I know that the Keller Williams and a lot of those places have got all kinds of education, but no, we have agents in our market that do not know the first thing about. And so what happens is the other side of the transaction has to help that agent get it right so that we can go to closing. And that happens all the time in our market.
Thank you.
Anything else?
Thank you, Ms. Jones. You recall, I think, I don't remember if it's the 2013 or 2015 session, when TAR went to the legislature, and we kind of wanted them to put a ceiling on how many hours of education we could have. And instead of doing that, they got a bill passed that said we could raise it 3 hours every 2 years if we wanted to. And that I personally thought was a little scary, but we do have the authority to do that. So who does it? They bring a recommendation, and then we decide whether we're going to do it.
We just got to be cautious.
Yeah, I agree.
I had the opportunity to attend an Arello meeting this past year, and it's fascinating. We are leaders when it comes to education, in getting a license and providing CE. And are you getting better? I don't know, but it sounds like we're not. And at some point in time, someone said, well, maybe commissioners ought to be fired if we're not getting better and we got more, it's costing us more money and more education, but we're not meeting the goals that we want.
Okay, I think I'm looking for Chairman Rose to come and tell me about the Inspector Committee. And thank you, Commissioner Arriaga, for attending that meeting.
Good morning. My name is Diana Rose. I'm the chair of the Real Estate Inspector Committee. The Texas Real Estate Inspector Committee met on Monday, January 22nd at 10 a.m. to discuss a very full agenda. At that meeting, the committee reviewed the changes to the financial responsibility and insurance rules that were proposed at the last commission meeting. The committee had considered asking the commission to make these changes based on a possible statutory conflict with language commonly found in inspector liability policies. However, the committee now believes this issue needs additional review to determine the best way to resolve any conflicts. As a result, the committee is recommending that the commission take no action on these proposed amendments when they come up for your consideration today on agenda item 16. Additionally, the committee is asking the commission to remand the issue back to the committee so that we can properly evaluate all of the issues surrounding the current financial responsibility and insurance requirements for the best solution, including recommending a possible legislative change as part of the sunset process. I will be available to answer questions when that agenda item comes up later on. The committee also discussed several issues surrounding the inspector's relationship with and duties to the inspector's client. The committee is looking to provide some additional clarity regarding these issues and will have some recommendations for your consideration at a future meeting. The Standards of Practice Subcommittee also met on Monday, January 22nd, prior to the meeting of the full committee. I would also like to take a moment to publicly thank all of the inspectors who made the trip to Austin to attend our January meeting. Inspector attendance at these meetings is invaluable because it provides our committee the opportunity to hear the ideas and concerns of inspectors from all over the state. With that in mind, the committee is meeting again at 10 a.m. on Monday, February 26th. We will elect our new officers at that meeting, and any inspector attending that meeting is eligible to receive up to 2 hours of continuing education credit. The Standards of Practice Subcommittee will meet at 9 a.m. prior to that full Inspector Committee meeting. That is my report, and I'm happy to answer any questions.
Are there any questions for Chairman Rose?
Thank you.
Thank you. I would now see if there's anyone in the House that has a general comment on a non-agenda item. Is there anyone here who has a general comment on a non-agenda item? Okay. We're getting ready to go into an executive session, but before I call that exactly, I'm going to remind you that if you want to speak on an agenda item, you need to turn a piece of paper in, and remind you also that when you get your turn to speak, you will have 3 minutes, and we would appreciate you not repeating what someone else might have said. That would be good. So, it is now time we will go into executive session to discuss pending litigation or obtain the advice of legal counsel pursuant to Texas Government Code Section 551.071. We will be in executive session for 45 minutes or so. But I call 45 minutes, which means we'll be back at about 11:47. So we go. We'll call the meeting of the Texas Real Estate Commission back to order at 12:08 and move on to agenda item 11, and Chairman will be passing the gavel for agenda items 11 and 12 to Commissioner Westcott.
Thank you. Okay, good afternoon. The item 11 is consideration and possible action regarding rehearing on the proposal for decision in the matter of TREC versus Billy D. Deeds. As you may recall, this PFD was before you at your November meeting. A motion for rehearing was filed and granted, and this is the rehearing on the proposal for decision.
I believe Mr. Robinson. Are you here, representing Mr. Deeds? Yes. Please come forward. You will have 5 minutes to speak.
Thank you very much. I appreciate the opportunity to come here, and I want to thank the Enforcement Committee for listening to us and allowing us to come back before you. I certainly don't want to waste your time, so I'm going to jump right into it. As you may remember from our last meeting, there were basically 4 issues of concern that the administrative law judge talked about. He said 1 was Mr. D's criminal conduct, number 2 was the nature of the repeated offense, number 3 was the short length of time since his last misconduct, and 4 was his failure to divulge his complete criminal history on his application. Let me address each of those and try and do it fairly quickly. Mr. Dees was charged in 2000 and 2002 at the ages of 18 and 20 for driving under the influence. Not driving while intoxicated, driving under the influence. That means if you're underage, any alcohol is considered a violation. Okay? He was then charged 9 years later in 2011 and then subsequently in 2014 for felony driving while intoxicated. And in the 2011 case, he was also charged for unlawful possession of a firearm. Now let's talk about the disclosure part first. I think that's the easiest and we'll go from there. On his application in 2016, he disclosed both the 2011 and the 2014 driving while intoxicated. He relied, as the administrative law judge duly noted and was put into the recommendation that was approved by this board, that he gave information on the DUIs, the 2000 and 2002 items, in his prior application in 2006. So he thought it was reasonable for him to rely on that disclosure, although he noted that they weren't actually in the application. The other thing that I thought was relevant is that the administrative law judge neglected to and chose not to recognize the fact that after the September application, Mr. Deeds received a letter from the commission asking about these charges, the ones that weren't on the application. In October, he got that letter and he replied, and that was several months before a ruling came down to deny him an application. And I'd like to read to you exactly what the administrative law judge said, because I find it somewhat disconcerting. He basically said, when asking why he would not include the October 16th disclosure information that disclosed everything, he said, because such findings would not support my conclusions and recommendations, I recommend the exception be denied and the proposed findings addressing those matters be rejected. Think about that for a second. He's saying because it won't support what I already decided, I'm not going to consider it. But the fact remains, in October of 16, 1 month after he filed his application, upon request from the commission, he disclosed everything. And by the way, you're also going to hear about that unlawful possession of firearm. Let me explain that to you. And just so you know, I'm this county attorney in San Saba County, so I prosecute DWIs every day. And I'll tell you for a fact, I've never represented anybody who's been a DWI ever until here. Okay? But the fact remains that Mr. Deeds disclosed everything. That unlawful possession of a firearm, what that boils down to, it was hunting season. We live in a rural area. It is not unusual for us to carry a firearm in the vehicle. The law says if you're carrying a firearm in your vehicle when you commit another crime, that you get charged with unlawful possession. The prosecutor apparently agreed with me on this. He put him on deferred adjudication. Deferred adjudication meaning you don't enter a plea, but you basically go through a process. It's kind of like a probationary period. And if you do that without any hiccups, they dismiss the charge. So he actually has 4 convictions. He was never convicted for an unlawful possession of a firearm. All right, now let's talk about the actual charges themselves.
You've got about 30 seconds, Mr. Robinson.
Well, I feel like you cut me really short, and there was a supplemental file that I didn't get to respond to. I really would appreciate you indulging me just a little bit, and I'm moving as fast as I can. Bottom line is, 2011 and 2014, he has felony DWIs. It's very unusual that you don't go to prison with a felony 3 DWI. Why is Mr. Deeds different? He's a remarkable individual. immediately following his arrest in 2014, and he wasn't tried for almost 2 years later, he put a device on his ankle. God bless the new technology. It's called a secured, continuous, remote alcohol monitoring device. That device monitors alcohol in his system 24 hours a day, 7 days a week, 365 days a year, and it's court admissible evidence. He has not had a drink since he had that arrest. He self-imposed that device on himself, and it was sufficient enough that 2 district judges who would normally send a man to prison said, we're going to put him out and reinstate his parole on one and put him on probation for the other. And a 3rd judge granted him an occupational license where he works as a car dealer. He's the number 2 man at the dealership doing their finance. So what I'm telling you is this man has done a remarkable thing. He hasn't had a drink in almost 4 years. The supplement that was put in that you may have seen, also, I'm going to address it very quickly, and that basically says that it's been a matter of policy that this commission does not grant even a probationary license for someone who's had 2 felonies within the last 10 years. I'm going to quickly go down. These are 20 cases that are agreed orders between the commission for a probationary license. And I'll just go through them very quickly, and I'm just going to hit the highlight. If you want the names and the case numbers, I'll be glad to give them to you. A 2016 DWI failed to disclose probationary license. July of 17, 2 felonies, a DWI in 09, 10, and 12, failed to disclose, put on a probationary license. 1 misdemeanor, 2 DWIs. 2017 was a misdemeanor DWI, okay? August of 2017, we gave him a probationary license.
Mr. Robinson, I'm going to ask you to wrap it up.
Okay, I'm going to just run through these real quick.
We have that information enclosed in here, so I'm not asking.
No, you don't have this. These are 20 cases that I pulled that are in direct contravention to what the supplement said and are in direct contravention to what your attorney's representing. That's not true.
Thank you.
You're telling me he shouldn't get a license because he didn't disclose, but he did, and you're telling me that 2 felonies are within the last 10 years are reasons to not do it, and I've got case after case after case to say that is not correct.
Thank you.
So I'm asking you to listen to what's going on here. I'm asking you to understand that this man's done a remarkable job. He's a hardworking man supporting 5 dependents.
Mr. Robinson, thank you.
I could go on and on. I'd be glad for any questions if you'd like to hear more.
You may step down. Thank you.
I'd like to ask one question.
Please.
The firearm, what firearm was it?
It was a rifle in the trunk.
It was a rifle in the trunk.
Yes, sir.
Thank you.
Thank you.
Mr. Moore.
Mark Moore, Standards and Enforcement Services. A few years ago, there was a prominent broker in the Hayes County area who was involved in a drunk driving accident. There was a lot of press on that. Somebody died. We got a lot of calls on that. Each time we had to say there wasn't a conviction. And each time we said that, someone said, well, did you know they had a lot of drunk driving crimes before that? And we were like, yes, but those were misdemeanors. We can't consider those. We only can do a conviction or felony. Here, we have 2 felonies, both it's a 2013 conviction and a 2016 conviction for 2011 and 2014 crimes. I'm not aware of any cases where we have been giving license on 2 recent felonies. The 6 cases he cited, none of them had 2 felonies that he cited in his brief. We don't have to wait for somebody to die to deny someone a license or revoke them. Here you have the 2 convictions. It's fully within your authority. Thank you.
And just so we're all clear on how I'm going to do this, I'm going to give the folks 5 minutes to speak, Mr. Moore an opportunity to respond, and then I would like y'all I'll bring them back up to ask questions. So does anybody have any further questions for Mr. Robinson? Any further questions for Mr. Moore? Given that, I will entertain a motion.
Mr. Chairman?
Yes, Commissioner Arriaga.
Counselor, we heard everything. and read everything that was sent by you, and I sit on the enforcement committee, that we voted to bring it back. I voted not to bring it back. I voted. And the reason for that is because I've been on this board, this commission now for 11 years, a long time. I just do not understand certain things that sometimes we did in the past. But I have one thing I can tell you, I've been straightforward in everything. I do not want someone in my community that has a problem in the past and still in probation, not one, not two, but 3 or 4 different convictions, and still, even then, they're granted a license to do the same thing I do. I got a son also in the business, and to me it's very important that when we take the oath of becoming a real estate licensee, we take it very seriously. And I'm a connoisseur of tequila, so I'm not lily white. I love my tequila, but I'm very cautious when and how, and to me it's very important. So, Mr. Chairman, at this time I move that we deny the, we accept the AJL's motion to deny his license.
A motion, do I have a second?
I second.
At this time, is there any discussion on the motion? Hearing no discussion, I will call for a vote. All in favor, please say aye.
Aye.
All opposed? No. Motion carries. Next is agenda item 12A. That is TREC versus Monk. Monk versus TREC.
Mr. Chair and Commissioners, in this case, Ms. Monk submitted an application for a license, and staff sought denial of the application based on the applicant's criminal history and failure to disclose that criminal history. The ALJ is recommending denial of the application for those reasons.
Ms. Monk, are you here, or is anybody representing Ms. Monk here?
Mr. Chairman,
Yes.
I move we accept the ALJ's decision to deny Ms. Monk's application for licensure.
I have a motion, to have a second.
Second.
Second. All in favor, say aye.
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 Motion carries. Agenda item 12B.
Mr. Chair and Commissioners, in this matter, Mr. Kettler pled guilty to 2 felony convictions, but failed to disclose those convictions within 30 days as required under the Commission's rules. Staff sought revocation of Mr. Kettler's license and a $3,000 administrative penalty. The ALJ recommended a 2-year suspension and a $3,000 administrative penalty.
Mr. Kettler, I believe you are here. Please come forward. We'll have 5 minutes to speak, and just as a reminder, we have the briefs from your case.
Okay. Good afternoon. I'm Mark Kettler. I'm here to defend myself on the 2-year suspension and the fee for my broker's license. I'm sorry. Yes, I did not disclose at the time. I did not feel there was anything to disclose except that I had been arrested at that point. So I did not disclose. There wasn't a decision made until roughly 15 months later, in June of the deferred justification probation, and that's the reason I did not disclose that. I made a mistake. It wasn't a real estate mistake. It was a consumer mistake, and I completed my responsibilities for probation, deferred justification probation. It is completely finished and complete and completely off my record. So I'm here to ask for the suspension on my license not to be suspended. It's my livelihood. It's my family's livelihood, so I am here to ask that. The mistake I made was bad judgment, bad immaturity, bad decision. and it was a one-time deal. It's the first time ever, and also I would like to note my real estate for over 15 years now is a spotless record, and I still need this license as a broker. So I'm here to ask for that. Thank you.
Thank you, sir. Mr. Moore, you may step down, sir. You may step down.
Mark Moore, San Angelo Enforcement Services. We agree with the proposal for decision and recommend its adoption. Ms. Mayo, the attorney on the case, is available to respond to Mr. Kettler.
Does anybody?
Oh, no, go ahead.
Yeah, unless you have something to add.
No, I was just going to ask if you have any questions, but.
No, yeah, well, let's hear from Mr. Kettler first. Does anybody have any questions for Mr. Kettler? Mr. Kettler, would you come back, please?
Well, mostly for Ms. Mayo.
Okay, let's start with Mr. Kettler. Did you have a question for him?
For Ms. Mayo.
Ms. Mayo, okay. Anybody have any more questions for Mr. Kettler?
I have one.
Please.
Mr. Kettler, you stated that one of the offenses, or that your offenses had nothing to do with real estate.
Yes, sir.
However, one of the offenses was entering, my microphone's not, here we go. It was entering your ex-girlfriend's home without her knowledge or permission.
Yes, it was.
Seems very real estate oriented. Explain that to me.
Sir?
Explain that to me.
I still had a key and a remote control to the garage of my ex-girlfriend's residence. And so I did enter. I still had possessions over there, and I did enter the house. And that was a charge.
Okay.
Any other questions?
So in other words, it wasn't entered a house through a window or a door. It was entered through the garage with a remote control.
Any further questions? You can step down again, sir. Thank you. Ms. Mayo, please.
Counselor, what choices did the administrative judge, law judge has? He gave a 2-year suspension of the license. What other choices could he had?
Pim Mayo, I'm an attorney in Standards and Enforcement Services. So we requested revocation, but the other available sanctions would be probated revocation, suspension, or probated suspension, or even just a reprimand with no revocation or suspension.
So the commission says, take the license away, but the judge says, no, only for 2 years.
Right, that was his recommendation.
Thank you.
You're welcome. And I'll speak to what Mr. Kettler testified to. On page 10 of the PFD, I believe. Oh, I'm sorry, it's page 6. The judge did include Mr. Kettler's testimony that he entered the house on more than once without permission, but only the incident on April 9th resulted in burglary charges. Do you have any other questions
Any further
for me?
questions? Thank you.
Okay, thanks.
At this time, I'll entertain a motion.
Mr. Chair,
Yes, Commissioner.
I'd like to, I move that we adopt the administrative law judge's decision for proposal in this case.
Second. I have a motion. I have a second. I'd like to call for a vote, or is there any discussion, rather?
Do we need to clarify on the record that suspension is for 2 years and a $3,000 penalty in the motion? If that's what. No. Okay.
No, we don't, as long as her motion was that we accept.
It was.
So that was what it was, yeah. Any further discussion? Call for a vote. All in favor, please say aye.
Aye.
All opposed? Motion carries. Next is agenda item 12C. Turner.
Mr. Chair and Commissioners, before you is the matter of TREC versus Michael Turner. In this matter, again, Mr. Turner is a current license holder who pled guilty to a felony and did not disclose the felony conviction on either his 2015 inactive renewal application or his 2017 active renewal application. Staff sought revocation and a $2,000 administrative penalty. The ALJ is recommending revocation and a $1,000 administrative penalty.
Thank you. Mr. Turner, are you here, or is anyone here representing Mr. Turner? Nope. At this time, I will entertain a motion.
That we accept the administrative law judge's revocation and $1,000 administrative penalty sanction.
Second.
A motion and a second. All in favor, please say aye.
Aye.
All opposed? Motion carries. That's the conclusion of these cases. I will pass the gavel on back.
You ready, Ms. Lewis?
I am ready.
Present.
Okay, this is agenda item 13, discussion and possible action to authorize settlement of recovery fund claims or to take other action on the listed cases. I will first note that items 13A and F are being pulled from this agenda as they are no longer eligible. The first case up for settlement discussion or action is Recovery Fund 18003, William N. Dilla and Mary Ann Vorsek Dilla versus Johnny Matthews Rabone, Jr.
Commissioner Stevens, do you have a motion?
I do, Madam Chair. I move that on case 10-003, that we authorize staff for payment of $15,175.44 plus interest, court costs, and reasonable attorney fees.
And that was 18003. Is there a second?
Second.
All in favor, say aye.
Aye.
Opposed, no. Motion carries. Agenda item C.
Recovery Fund 18005, Pedro Silva versus Juan Olivares.
Commissioner Arriaga?
Yes. Regarding Recovery Fund number 18-005, Madam Chair, I move that we authorize payment of $20,000 plus court costs, interest, and attorney's fees.
I have a motion. Do I have a second?
Second.
All in favor, say aye.
Aye.
Opposed, no. Motion carries. Agenda item D.
Recovery Fund 18-002, Dennis J. Hine versus Philip Lee Chenault.
Commissioner Fight Miller?
In case number 18002, I recommend the staff to authorize payment of $8,100 in actual damages and $78.80 in attorney fees plus court costs and interest.
Second.
I have a motion and a second. All in favor, say aye.
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 And opposed, no. The motion carries. Agenda item 13E.
Recovery Fund Case 18004, Act Daddy, Inc., and Timothy J. DeWeen versus Omar and Judy Enriquez.
Okay, I believe Mr. DeWeen is here. Are you here, sir? Okay, this is not the opportunity to retry this case. However, I will give you 3 minutes to say something if you want to.
Thank you. I understand that already.
State your name because we may have said it wrong.
My name is Timothy J. DeWine.
DeWine, okay.
And I think that comment was prompted because of the stack I brought. I understand you didn't have time for the handouts, but I'm going to refer to items that were in the original TREC complaint, and the stack of them is there. I'm not here to argue. Is Ms. Mayo? I'm not here to argue with Ms. Mayo's decision. I'm actually here to use that to explain why I don't think you should pay any money out of the recovery fund on this case. First of all, I met the Enriquezes in 2004, became very close personal friends of theirs until about 2012 when we had a disagreement over something completely not real estate related. It was over repairs done to his house. Unfortunately, what should have been not taken up as this would have been an unlicensed entity, it was conjoined, and there was a finding, and I was given a $1,000 fine and ordered to take some classes, additional classes. I took 30 hours of agency. All that was completed. Unfortunately, the lawyer representing the other party took that finding from the original TREC complaint, went down and got a summary judgment, and brought that back to you to ask for recovery claims. Unfortunately, I never had my day in court. This was all done on the sly. What I wanted to tell you and point to those is Mr. Enriquez lied to you throughout the complaint, and I could point them all out. I have with me an email where he agreed to pay, etc. I'm just asking that you don't reward a scandalous or a scoundrel further by awarding him money out of the recovery fund. He's already gotten 2 free house remodels out of it, which I'm paying for. Believe me, over $100,000, and it would really add insult to injury if he was able to siphon another $50,000 from the fund. So I'm asking that you please do not pay that.
Thank you.
Thank you. And also, I hope you don't revoke my license. I've been a realtor this is my 20th year, and it's ironic that the only TREC complaint I've ever had was somebody that was supposed to be a friend. So, thank you for your time. I appreciate it. Any questions? Okay.
Any questions?
Madam Chair?
Yes? For him?
Yes, sir.
Mr. DeWine, sometimes I think the public takes advantage of the Texas Real Estate Commission. They know money's out there. So I hear you say that they actually got what they were complaining about because you're paying over $100,000 in their homes, and they're going overboard and wanting additional money. Is that what you're saying?
More or less, yes. What happened is he and his wife stated in their claim that they thought the work that I did on their home separately from a real estate transaction was something that is
I'm going to interrupt you. It's okay. I just want to get in that. What would happen, Madam Chair, if we wait
Well, that's what we need to ask counsel.
on this one in order to really vet that out?
That'll be the next thing. Okay.
Yeah, if I could just say one more thing. I never got a chance to have a face-to-face with anybody from TREC. It was, I think I unfortunately overwhelmed them with documentation, and I also was switched in between 2 investigators, and I would appreciate the time. I would be more than happy to come up here for as long as it takes to help you reach some conclusion based on facts that we could share. It's just hard when I send this much up here and I have no.
Thank you.
Thank you.
Thank you.
So, okay.
You can rest assured that we do read any information that comes through this commission. So even though you may not meet with someone, but you have now, you can rest assured that anything that is sent will be read, at least by some.
Okay.
Thank you.
General Counsel, no, you can sit down. Thank you.
I would just like to make a distinction between a complaint case and a recovery fund case. A complaint case is where he gave the information to, and we investigated and came up with an order, as he described, that Ms. Mayo was involved in. A recovery fund case is a case that we look at after a consumer has gotten a judgment in a civil court. So the place to defend that against that judgment, against that judge saying that there were actual damages, would have been in the civil court. We cannot change the judgment that was granted in the civil court. We're bound by that. The recovery fund exists to pay claims where a judge in a civil court found that there were actual damages due to a real estate transaction. And that is what this case, the judgment in this case, found.
So it's truly stated by the information given and not more of a personal matter. Because it seems to me that you guys got into a dispute, but we've gone through the process
Right,
So-
we've gone through the process, and the place where he should have made these arguments was to the judge in that case. We can't second guess what went on in that civil court. And in that way, it's not related to a complaint, a TREC complaint. That's a separate track, even though they may have used any agreed order as part of their evidence. That's separate. The civil case is separate.
That's all they used.
Okay.
And we're awarded a summary judgment based on that.
Madam Chair?
Yes, sir.
Counselor, could the judge have made a mistake?
We can, if we can't retry the judgment. We can have the Office of the Attorney General dispute whether some of these items are validly related to real estate brokerage. That's as far as we can go. In that case, all that would do is reduce the amount that could be recommended for payment from the recovery fund, and then we put it in the judge's court, not in our court, in our decision. But the judgment is still going to stand. The underlying judgment. It would just be how much we pay from the recovery fund. So we could ask the Attorney General to look at this and see if they think that there's a argument to be made. Understand we do pay for those services.
Absolutely. We got to save the integrity of just giving people money every time they say they've been wronged. And that's what it's for, I understand.
Right.
And rightly so. At the same time, we got to be more judicial in making sure that we've turned over all rocks and make sure it's correct. In the short time I've been on this commission, we've given away too much money, way too much. And sometimes I feel there's a conspiracy going on because they know it's available to take advantage of us. So I don't know how to proceed, Madam Chair, to send it back to the Office of Attorney General.
I guess we need a motion on this case.
We've gone through the process, so can we just go forward and just see where it turns out?
You can certainly
Yeah.
make a motion.
Case number 18-004. I move to authorize payment of $50,000, which is the maximum by law.
I have a motion. Do I have a second? I have a motion. Do I have a second?
You have a second.
I have a second. Okay. All in favor, say aye.
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 I heard two ayes. And opposed, no?
No.
No.
Then I
Madam
need
Chair, I'm ready to
then I
make a
need
motion.
another motion.
I move that we follow instructions from council and see how we can refer this back to, or refer it to the Office of Attorney General to, I don't know what the right term is, review and see if we can do anything about this. But giving $50,000 outright does not, according to what I heard today, is not quite fair.
Okay, I have a motion that I believe I can summarize by saying that you want this remanded over to the Office of the Attorney General to determine how much of this might have been not brokerage activity.
We would challenge it in civil court. The OAG would challenge it.
Whatever way.
They
that-
determine that it's a
That's
viable
basically your
case.
motion.
Can I add some discussion here? Just so we're clear, Commissioner Arago, what you're asking. I mean, this does require attorneys. There's costs associated with all of this. So, while on one hand we may be saving the recovery fund money, we may be adding costs in other places that could potentially cost the government money. So we just have to be cognizant in doing something like that.
Okay, wait. Do I have a second to Mr.? Okay, now I have a second.
There's a saying in Spanish, and forgive me for going into Spanish, but it translates, and I think you'll understand. Un mal arreglo es un buen pleito. Un mal arreglo es un buen pleito. A bad arrangement is better than a good fight. I understand, but at the same time, the integrity of the fund has to be protected.
Okay, I have a motion and a second. I'm calling for the vote. All in favor, say aye.
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 And opposed, no.
No.
Moving forward to agenda item 14. First time that's ever happened.
Agenda item 14 is discussion of possible action to adopt amendments to 22 TAC Section 53565, responsibilities and operations of providers of qualifying courses. These amendments were published in the December 1st Register. And the amendments implement changes made to Chapter 53 of the Texas Occupations Code by House Bill 1508, adopted effective September 1st. These changes require education providers to notify potential students before they enroll in an occupational licensing program that a criminal history may make them ineligible for the license they seek. The statutory changes also provide authority for licensing agencies to order reimbursement to be paid to the students if the provider fails to give the required notices. In addition, subsection H1 is amended to clarify that all final examinations are to be closed book examinations. This change was recommended by the Commission's Education Standards and Advisory Committee. No comments were received on this proposal, and staff recommends adoption as published.
Commissioner Westcott, do you have a motion?
Yes, Madam Chair, I have a motion. I move that staff is authorized on behalf of this commission to submit for adoption amendments to 22 TAC Section 535.65, responsibilities and operations of providers of qualifying courses, as presented to the Texas Register, along with any technical or non-substantive changes required for adoption.
I have a motion. Do I have a second? Second. And I have discussion or questions?
I do. Madam Chair, if I may. I believe that we do have concerns because there are people that are not informing the commission when something is not done properly, but I think that the manner in which we're doing this is not the proper way to do this. Let's just say if we went to purchase a car, and if every Texas agency, like drivers, every one of the agencies in Texas had to make the dealer provide a form and put the liability on the dealer. Can you imagine the logistics of that? So I think that we need to remember that every license applicant should be responsible, and it's their duty to do everything they can. And if there's going to be a problem, we are the agency. Perhaps we should inform them and provide education about where to go, but I don't think that we should be putting this on the education providers.
That was a statutory change by the House this past session. It applies to all regulatory agencies.
Can you please tell me the authority?
It is House Bill 1508, and it applies across the board for all licensing agencies.
Do you know exactly where, like what paragraph or?
I do not know, but Tony Slagle can get that information for you after the meeting.
Thank you.
And it's also been the law since September, so we're just implementing it into our rule.
Right. And actually putting it in a rule will help providers keep up with it.
I'd like to also mention that even though it may be, I have not read it, but it's the manner in which we do this. It's not that it's how we do this, that I don't believe in passing liability to others. I think that we need to remember that every applicant should be accountable and responsible, just as the agency is and each of us is for our own duties that we have. Thank you.
Okay, are there any other questions? All in favor say aye.
Aye.
All opposed, no. Motion carries. No, thank you. Agenda item 15, and I have one speaker on a couple of these. So.
Agenda item 15 is discussion and possible action to adopt amendments to 22 TAC Chapter 537. And these are our standard contract forms that the Broker Lawyer Committee brings forward to us every couple of years following a legislative session. So A through F are our standard contract forms. These have gone through several versions and comments, revisions by the Broker Lawyer Committee. What they're bringing forward to you now is their recommendations for adoption. The specifics are highlighted in the write-up, but you can look on the forms themselves, and the highlighted rainbow of colors on these forms, you've got green, red, and blue, since it's been through several different iterations, are what the committee is recommending be adopted as the new standard contract forms. The main highlight that we got a lot of comments in support of is the change to paragraph 5, which now would require the earnest money to be delivered within 3 days of the effective date. If the third day falls on a Saturday, Sunday, or legal holiday, the earnest money is due on the next day that is not a Saturday, Sunday, or legal holiday. If that doesn't happen, the seller has the right to terminate the contract. So do you want to take A through F first, or do you want, then do the 2 new amendments, or do you want me to go
I
ahead?
think we should do A through F first.
Madam Chair, if you don't mind, I do have comments and questions, and I think that because they're numbered, they're not labeled on our agenda. If you don't mind, let's please vote. No, but we're
You
going to
wanna do
vote
each
on,
one?
yes, please.
Even though the changes on all 6 contracts are the same.
I guess I'm confused.
Okay,
I
well-
think that if we are,
What she was proposing is that A through F would be the 6 contracts, and the changes in each contract are the same. And then the 2 new forms be separated out as separate motions. The 2 completely new form, the appraisal form and the hydrostatic testing form. So if you had a comment on any contract, you could make it on the first motion, which doesn't exist yet.
is her comment including all the changes on all the forms? Are you going to vote on, are you intending to vote on A through H?
No, through F.
No,
Through
the
F.
6
G and H
contracts.
are new, so since there are people who want to speak in them, I thought we should just take the standard contract forms separately from the 2 new addenda.
There's 6 contract forms. The
well,
changes are the same on each.
Let me just say, I have a comment on the condominium contract, and because all we have is numbers, I'm not sure which one it is.
Okay. The condominium contract.
I think it may be 3012, but the numbers
It
are-
is. It is under 3012, yes.
Yes.
What page would that be?
It's on page 213.
Well, let's see, could we then do A through E and then separate the last 3? Okay. Then I would seek a motion on agenda items A, 15A through E, and I do have a person who wants to make a comment on A, but let's get a motion on the table first.
Okay.
So, somebody want to give it a go?
Madam Chair?
Yes.
Move that staff is authorized on behalf of this commission to submit for adoption amendments to 22 TAC Chapter 537 and the forms adopted by reference as presented to the Texas Register, along with any technical or non-substantive changes required for adoption. The forms adopted by reference and these rules will be available for voluntary use upon adoption and will be required for mandatory use on May 15th, 2018.
And those would include the unimproved property contract, the residential contract, farm and ranch contract, the new home improved and unimproved. Is that correct?
Correct.
Holding the condominium contract as a separate motion. Is everybody clear on that? I need a second. I have a second. Do we want to let Bob Baker come and speak for 3 minutes? Or less? On A, please, Mr. Baker.
It's kind of a tricky question. Do we want Bob to speak?
I'm timing you, baby.
Thank you.
Identify yourself.
I'm Bob Baker. I'm a broker in Collin County. And I want to congratulate the Broker Lawyer Committee and the Commission for these changes. It's a good thing that we've done because we've been kind of on our own out in the field making these changes and practicing law and getting all kinds of trouble, as Commissioner Miller knows. However, having said that, I think there is a really important concept in our contracts, and that's a consistency factor. One of our challenges with paragraph 5, specifically with the earnest money, is that we've changed how something ends. Before, when something ends, it ends. That day, we don't move it to the next non-holiday or my birthday or whatever, it ends. The challenge in the business is whenever we do anything like that, it creates a real challenge with the agents. Understanding, well, this is a Pandora's box, we did this, or what about this? We saw this when we made the change in paragraph 23. People wanted to make other things end at 5 p.m. And so this creates a challenge. We've got a 3-day thing in there, and we understand the challenge with title companies and holidays and weekends, but it would seem an easy fix is 4 days or 5 days. But to make this thing change so that if it ends up on a weekend or a holiday, we roll to the next day is inconsistent, and it creates a challenge, and the agent's going to begin to look at other kinds of things in our contracts and creates a problem. Now, to Commissioner Saraga's thing, bad deal is better than no deal at all. And so I think we've gone down a good road here. It'll be a work in progress. I want to be on the record, though, so later when it happens, you go, you know, Bob was right. This is going to create a challenge, and we need to make adjustments later.
We're never going to say
We're never going to say that, okay. But at least it's good what we've done. I don't expect us not to adopt this, but I want us to keep in mind that this is going to create a challenge, and that consistency factor is very important. Thank you.
And I do know that you had comments in our record about this previously, and I appreciate you making them public here and appreciate your time in other places and on the Broker Lawyer Committee at another time. I have a motion and a second. Is there any other comments? All in favor say aye.
Aye.
And opposed, no. Motion carries. So now let's have a motion on 53737, the condominium contract, and then we will discuss it. So, Bob, you did such a good job. You want to just go ahead and do the next one since it's just one contract?
Same motion?
Same motion.
A motion, but on just the residential condominium contract.
Read the motion, and then you're just doing the condominium contract.
Move that staff is authorized on behalf of this commission to submit for adoption amendments to 22 TAC Chapter 537 and the forms adopted by reference as presented to the Texas Register, along with any technical or non-substantive changes required for adoption. The forms adopted by reference in these rules will be available for voluntary use upon adoption and will be required for mandatory use on May 15, 2018.
This is in reference to 53737 contract 30-12.
Correct.
I have a motion. Do I have a second?
Second.
I have a second. I have discussion.
I do, Madam Chair, that I appreciate all the work, time, and effort that is being put into the Broker Lawyer Committee. This comes from practical experience, and and just from the principle of let us remember that we need to preserve the freedom of contract, that real estate is based on parties agreeing on what their best is for each of them. And that's the principle of real estate. We represent one party and another realtor, hopefully, or somebody else represents the other. And this contract is is saying that a seller at the seller's expense shall deliver the document. So that is my objection, that I think that it should be negotiated by the parties. And that's it. And to me, that is very important. If we start saying or marking or instigating who should do what, I think that then we are not preserving the freedom of contract, and to me, that is principle. Thank you.
Okay. Thank you. Are there any other comments? All in favor say aye. Aye. Opposed, no. Motion carries. Got it? One no. So now we would look at a brand new form called the Addendum for Authorizing Hydrostatic Testing, which appears on page 223 of 328. And I might trouble someone else instead of Commissioner Leonard to make a motion to move this one forward, and that motion is still on page 159 of your manual, and you would reference new form 48-0 in your motion. If somebody was willing to read.
Madam Chair?
Yes, sir. Commissioner Arriaga.
I move that the staff is authorized on behalf of the Commission to submit for adoption amendments to 22 TAC Chapter 537 and the forms adopted by reference as presented to the Texas Register, along with any technical and non-substantive changes required for adoption. The forms adopted by reference in these rules will be available for voluntary use upon adoption and will be required for mandatory use on May 15, 2018.
Okay, and that's 537.55, contract form 48-0. I have a motion. Do I have a second?
Second.
Okay. Has anybody got any comments?
I do, please.
Okay.
On this form, I have a concern on the commission recommending that the seller, on B, that the seller shall be liable for all damages, or the buyer shall be liable for all damages, or the amount of damages. I agree with the form. I think that it's great that we have a form, but I don't think that it is the role of the real estate agent to be out there making recommendations. I think that on the one end, we tell real estate agents do not practice law on the special provisions, and on the other end, I think that this involves advice that perhaps we may not be the best at doing, and so that is a concern. And if we had a form just like this to present every time that we have to perform an inspection on a home, we would really have sellers and buyers thinking, my goodness, if something happens, who is going to pay for it? And in reality, these things happen all the time, unfortunately. But the parties, a lot of times they work it out on their own. So I think the form is really good, but I would delete paragraph B. Thank you.
So if I may, the way it works with Broker Lawyer Committee, which is a statutory committee, they recommend forms, and we cannot change the forms. We either do a thumbs up or thumbs down, accept them. So if this form is not acceptable, you would have to send it back to the Broker Lawyer Committee, which debates these issues and looks at all the comments from the consumers. I will note that the Trade Association and most of the people who commented on both of these new addendums were in favor of adoption.
I got a question, Madam Chair.
Okay.
I've never sold a house. I haven't sold a house in years, decades. The recommendation would, Commissioner Stevens, would be what? You would think that if this portion was eliminated, it goes back to where it is today. And what is the situation today if that was not on there?
There's no form.
There's no form by the Broker Lawyer Committee. That the contract does require that authorization be given in writing, but there hadn't been a vehicle by the Broker Lawyer Committee recommendation previously. So there's been a variety of different things that either license holders have written or attorneys hired by license holders have written. So the Broker Lawyer Committee wanting consistency.
This is the second draft they have, or the second time we've had it, the second time it's been through comments from industry. And this is sort of like the final blow or not. And our choice is to move it forward into industry or send it back to broker lawyer for something else. And I would encourage you as commissioners, as we walk through the process of having broker lawyer look at these things, they would certainly look at our comments as well if you wanted to send it while they're looking at it in their room, or go to their meeting and talk to them.
Madam Chair, if I may, I did make the comments during the last commission meeting. Hopefully they're listening. And again, I think that this is a great form, but if we use this same form when we perform an inspection on every home that we sell, this would destroy many deals. And for the same reason, I think that should be the thought. So it's not rather the quantity of times, how many times until we get it done. I think that we should focus more on, are we getting it done right? Thank you.
Any other comments? Nope. All in favor say aye.
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 And opposed?
Me. Thank you.
Motion carries. Okay, the last form we also have a speaker on, and you want to set it forth, Ms. Lewis?
Yes, this is the addendum concerning right to terminate due to a lender's appraisal. This was created to address situation where parties create a contingency to the contract based on the appraisal performed by the lender and termination rights or waivers associated with that contingency. This form was requested by many in the industry and is supported by the Trade Association. And it too there was a lack of consistency in the industry in this, and during the hot market, there were a lot of license holders who were actually practicing law without a license by writing these contingencies in, and or attorneys were hired that were writing these contingencies in. So it came out of a demand from the industry to have this form.
Okay, as we have been doing, I would seek a motion on this specific form, the motion being on page 159, the form being on page 225, and then a second, and then we would have someone come forward who has asked to speak and anyone else who wishes to speak. Motion? Jan?
So we read the same thing that has been read. Got it. I move that staff is authorized on behalf of the commission to submit for adoption amendments to 22 TAC Chapter 537 and the forms adopted by reference as presented to the Texas Register, along with any technical or non-substantive changes required for adoption. The forms adopted by reference in these rules will be available for voluntary use upon adoption and will be required for mandatory use on May 15, 2018. This is specifically for Form 49./0.
Yeah, 537.56. Do I have a second?
Second.
Okay.
I have.
Okay.
On this form, my concern, I think it's great that we do need to address the issue, but I think that the manner in which we do it on the 3 paragraphs is drastic. Sort of like we don't know what is going to happen until the appraisal comes back. In a market such as Houston after Harvey, we have so much need for housing that if there is a good home out there and it comes out, people are going to take desperate measures. And sort of like before you go and you have lab work done, I try to give you an example so that people understand it. If you make a decision without knowing what your prognosis is, are you going to say, and this is what this form is telling me, I'm going to do this, like I'm not going to accept any medical assistance, or I'm not going to fight this, and you don't know what it is. I think first we need to find out what is the appraisal. A lot of these situations get worked out, but I think that people deal with it as the need arises instead of doing it in advance, because I think that this is going to create more problems, and what we're trying to do is solve them. So that is my concern.
This is not required to be used with every contract. It's only required for license holders to use when their principal wants to have a contingency for the appraisal, or to not, to waive a contingency for the appraisal. Yes. But the regular contract already has a provision under the third-party financing addendum for property approval, and that stands unless one of the parties wants this addendum.
Madam Chair, do you have someone's going to be addressing this, you said, from the public, or not really?
Yeah, Bob Baker has put his name in. Did you want to say something?
No.
Okay. Oh, and now I have someone else who wants to say something.
There you go.
Mr. Baker? Please state your name again for the record when you get there.
I'm Bob Baker, a broker in the Collin County area. And again, thank you for doing this. And General Counsel Lewis is right. We were clamoring for something. Here's the challenge. One of the concepts that I believe in our contracts is clear and understandable language. We've done a good job. There are a few paragraphs that a little too much attorneys involved. I'm sorry, but that's just how that is. But for the most part, clear and understandable. Now, this form addresses an incredibly important issue. I've had multiple conversations with other respected brokers, with attorneys, going through the process in these 3 paragraphs, and have somewhat of a sense of what I think the paragraphs say. Our challenge is I've got to go back and train a bunch of agents, as Commissioner Miller does, as Ivy Boland does, as you will have to be doing. And right now, I'm not sure I know what that training is. When I look at these 3 paragraphs, it's so much going to depend on what's going on in the transaction. I cannot imagine a seller ever using number 3 unless he's got a terrible negotiating position. Otherwise, why would seller ever accept item number 3, paragraph 3? Just wouldn't do it. I would really like to see us be able to do something in the way of training, maybe working with TAR, the fine attorneys there, maybe something that the commission would put forward and the TREC advisor explaining these a little bit better, because in my multiple conversation with people whose opinion I really respect, we're not in agreement on everything, especially what number 1 and 2 says. And that's a challenge. And imagine as we're standing up trying to explain it to our agents who are saying, no, don't explain it to me. What I put in there, what I put in there, it's going to be a problem. So while we're certainly going to do this, no question, we've got to have something. We've got to find some way to get the word out to the field. This is really what these mean, and this is how you're going to train your people to do them, or we're going to have a disaster. And I would really ask that you do something. Because right now, we looked at this theoretically at the beginning, everything was good, but then I had a transaction in one of my offices just last week in which an attorney, a good title company attorney, who had tweaked number 2 and added some additional language, taken this language, and set up a situation where the buyer, if it didn't appraise, would pay an additional 1/2 of the difference between the sales price and the appraised value. And the buyer just absolutely said, well, that means the seller is going to drop the price down for the other half. Well, that's not what it said. And it creates some real confusion. That's going to happen if we don't get some real training out there, say, this is really what it does mean. So if you can do something in that direction to help us out there, thank you for doing this, but give us some help. Thank you.
Thank you, Mr. Baker. I have Mr.
Chair.
Yes, I'm sorry.
No, sir, I just have a comment that even if we come up with a great form, we still, attorneys and the public, they have the right to go and come up with their own, just so everybody's clear on this, that even if we come up with the best, there's always, because the nature of real estate is, every property is unique and every party has different needs. So I don't think that we can prevent that completely, but we are going to try
address that. Excellent point, Mr. Stevens. Because I'd like a clarification. And thank you for bringing that up, because I meant to ask this. I understand that there's enormous latitude for attorneys to do things in Texas. And good attorneys out there, good real estate attorneys, are trying to help us in our transaction because we're not attorneys and we need that help. I would like some clarification, the degree to which an attorney, even an attorney representing a principal in the transaction, can so tweak this promulgated language that we're going to end up with these challenges. Is that true, that attorneys representing a principal in the transaction can take this language and so begin to tweak and alter it? Clarify that for me,
Ms.
please.
Lewis is behind you. I think we're going to let her answer that question.
Yes. That was easy. Okay. Well, you're right, Commissioner Stevens. It's going to always be a problem no matter what we come up with. But if we come up with a little better form and some training, I think it will help a lot. Thank you.
Thank you, Mr. Baker. I have another speaker. Mr. Tolar, would you come forward? Please state your name for the record.
Scott Tolar. I agree with Mr. Baker's sentiments on this. There is something that does need to be addressed, and this form will help to do that. Here in the Austin area, we have a lot of companies who have come up with their own forms to attempt to address this issue. Yet, unfortunately, people on other sides of transactions aren't aware of what some of the legal language means, and a form that is provided by the state would definitely help us go a long way in this particular issue. Thank you.
Okay, so you're in favor of the form?
I am.
Okay, thank you. Any other comments? Any other questions?
I have a question for Ms. Lewis. So this form is contingency. This is not a mandatory form, just so everybody's clear, because Mr. Baker was saying that they're going to be training. Right. So for the record, we do not need to train people. This is totally optional.
Well, in one respect, it's mandatory in that if you are going to have an appraisal contingency as part of your contract, then you would, if you're a license holder, you need to use this form to do it. So you don't have the situation that our last speaker just said, where you've got different people writing different types of paragraphs that don't have any consistency in them. But you do not have to use, just like any of the addendums, you do not have to use them if they're not part of the deal in your contract.
Thank you.
Okay. All in favor say aye.
Aye.
And opposed, no. No. Motion carries. Okay, where are we?
Okay.
Agenda item
16.
16. This is the inspector thing.
Yeah, this is discussion and possible action to adopt amendments to section 535-211 professional liability insurance or any other insurance that provides coverage for a violation of subchapter G of chapter 1102. As you heard from Chair Rose this morning, this committee is recommending that no action be taken at this time on these amendments and that the issue be remanded back to the inspector committee for a continued discussion and examination of proposed legislative fix for all consumer recovery issues to be implemented as part of the agency's sunset review.
Okay. Does someone wish to make the motion on page 252? You got it, Laura? Thank you.
It is moved, and if I can get this in front of me. It is moved that the commission take no action on the proposed amendments to 22 TAC number 535.211 professional liability insurance, and that the commission remand this matter to the inspector committee to allow for continued discussion and examination of a proposed legislative fix for all consumer recovery issues to be implemented as part of the agency's sunset review.
I have a motion, I have a second.
Second.
I have a second. Any discussion? All in favor say aye.
Aye.
And opposed, no. Motion carries. Agenda item 17.
Agenda item 17 is discussion and possible action to adopt amendments to 22 TAC section 541.1 criminal offense guidelines. These were recommended by the enforcement committee at the last meeting, and they were proposed. No comments were received. However, due to the large backlog of criminal history background checks and occasional SOA decisions contrary to staff recommendations, staff is re-evaluating all of their processes connected with this and Chapter 53 requirements. Staff may have additional questions or recommendations for the enforcement committee to reconsider on this rule in the next few months, and therefore staff is recommending that we table adoption until the next meeting in May.
Commissioner Williams?
Madam Chair, we move that this item be tabled until May 2018 meeting.
I have a motion, I have a second.
Second.
I have a second. Any discussion? All in favor say aye.
Aye.
Opposed, no. Motion carries. Agenda item 18.
This is discussion and possible action to adopt amendments to 22 TAC Section 535.52, moral character requirements for individual applicants. Again, this was up for adoption after recommendation by the Enforcement Committee. However, for the same reasons as in the last rule, staff is requesting that this adoption be tabled until the May meeting.
Commissioner Williams?
Madam Chair, we move that staff is authorized on behalf of the commission to submit the proposed amendments to
Oh,
what?
it should be on page 265.
Table.
This is another tabling.
Oh, we're still on the other one, okay. He got me.
Move that this item be tabled until the May 2018 meeting.
That's a motion to have a second.
The first time.
And this is the table motion, not the other motion. So any discussion? All in favor say aye.
Aye.
Opposed, no. Motion carries. Agenda item 19.
Agenda item 19 is our first proposal today, discussion and possible action to propose amendments to 22 TAC Section 535.4, failure to answer, failure to attend a hearing in default. The proposed amendments increase the time to respond to a notice of alleged violation from 20 to 30 days. This amendment is being made to conform with Rule 533.3, which the Commission amended in November. The word administrator was also changed to executive director to conform to current statutory language.
Okay.
Oh, now.
Now.
I'm on the right one.
Okay.
Move that staff is authorized on behalf of this commission to submit the proposed amendment to 22 TAC 533.4 failure to answer, failure to attend hearing, and default, along with the technical and non-substantive changes required for a proposal to the Texas Register for publication and public comment.
I have a motion to have a second.
Second.
Any discussion? No one is in to sign. All in favor say aye.
Aye.
Opposed, no. Motion carries. Agenda item 20.
Discussion and possible action to propose amendments to 22 TAC 537.45 Standard Contract Form Number 38-5, which is the notice of buyer's termination of contract. The Broker Lawyer Committee recommended revisions to this contract form to reflect some additional rights of termination for buyer under these new standard contract forms. And you can see, if you look on page 277, what they're proposing. The amendments are highlighted in blue.
Madam Chair?
Yes.
Agenda item number 20. I move that the staff is authorized on behalf of this commission to submit the proposed amendments to 22 TAC subsec chapter 537.45 standards contract for TREC form number 38-5 in the form adopted by this reference, along with any technical and non-substantive changes required for this proposal to the Texas Register for publication and public comment.
I have a motion to have a second. Second. I have no speakers. Do I have any questions? All in favor say aye.
Aye.
And opposed, no. Agenda item 21.
Discussion and possible action to propose new section 537-0.57 standard contract form number TREC number 50-0, and this is a proposed new notice of seller's termination of contract to reflect the right of termination under the new paragraph 5 that was adopted in the standard contract. I will note that there is one typo that needs to be corrected, and that is on page 283, where it says buyer failed to deposit. That should be buyer failed to deliver, since deposit was changed to deliver in the contract forms.
Okay.
Madam Chair?
Yes.
I move that staff's authorized on behalf of this commission to submit the proposed amendments to 22 TAC 53757 standard contract form TREC number 50-0 and the form adopted by reference, along with any technical or non-substantive changes required for proposal to the Texas Register for publication and public comment.
I have a motion. Do I have a second?
Second.
I have a comment on this one that I want to go public record. In paragraph 5, the seller has two choices: just to walk away and put their house back on the market, or to exercise the remedies in paragraph 15. And I don't see that the seller has elected to tell the buyer in this form which choice they're going to make. And I think broker lawyers should consider looking at that.
Has that page?
That was on page
283.
283. That's just a comment.
Okay.
Just note that, please. Okay, are you going to speak on this form? Okay. Oh, on the next item. Wait, we got to vote. We got to vote. So any other comments on this form? All in favor say aye.
Aye.
Opposed, no. Motion carries. Agenda item 22.
Thank you, Madam Chair. It's Tony Slagle, Government Affairs for the Commission. The next item is to open up the review of 22 TAC Chapter 537, Chapter 539, and Chapter 543. At your last meeting in November, you adopted a rule review schedule, and as part of that schedule, the next step is to open up the review of those three chapters of our rules.
Okie dokie.
Madam Chair, we move that staff is authorized on behalf of this commission to submit the review of 22 TAC Chapter 537 Professional Agreement of Standard Contracts to 22 TAC Chapter 539 Provisions of the Residential Service Company Act and 22 TAC Chapter 543 Rules relating to the provisions of the Texas Timeshare Act as presented to the Texas Register.
Second.
I have a motion and a second. Is there any discussion? All in favor say aye.
Aye.
And opposed, no. Motion carries. Agenda item 23. A. 23A. A. 23. Okay, 23, which is about the long-term facilities plan. Okay.
Moving through the agenda to 23, I had hoped to, it was requested at the last meeting that I provide the commission an update to the long-term facilities master plan. If you have been following the news, about 2 weeks ago, the Facilities Commission, much like this commission, members met, went into executive session, and then when they came out of executive session, they dismissed 8 members of the senior staff, including the executive director of the commission.
Lord.
That was fun.
Several of those members were members that we had been in direct communication with about our project. Fortunately, there was one gentleman who was one of the deputy executive directors who was not dismissed, but was appointed as the interim executive director for the commission. And so I spoke with him a few days later, and he assured me that our project was still a high priority for the commission, but that they would need to hire some new people. Obviously, that is their first priority. And so he asked for a few months grace period before we began to try to advance our project with them. So I promised him I would report that to you and then stay in touch with him, reach back out to him in early April to see if there was anything that we could actually do so that at the May meeting, perhaps I'd be able to give you a more substantive report. I'm happy to answer any questions.
2 questions. Number one.
Certainly.
Was it public that they were removed? I'm sure.
Yes.
I missed that. It had to do nothing about our building, right?
Nothing about our building.
Okay. Why were they asked to be removed?
Since I was not involved in that, and it was done in executive session, the action was simply to dismiss the 8 members, including the executive director, general counsel, one of the deputy executive directors, assistant, HR, anyway, a bunch of
Not important, but we need to learn why and from that. But really, what is the status of the building?
So we need to have authorization, which was included in our bill, the draft, authorization to the commission, to the Facilities Commission, to enter into an agreement with this commission to develop the building on that site. Okay, that was removed from HB 2212 before it was passed. And the principal reason that was given was that there was inadequate communication between the Facilities Commission and other members of government leadership with respect to some specifics around our project. And so it wasn't ready to be advanced. As we go through the sunset process, we will have a bill in 2019, or the commission will cease to exist if there is not a bill continuing the commission. And so we'll have a bill, and our negotiation with the Facilities Commission is to both advance the design of the project, and secondly, to ensure that adequate communications are made prior to the time that our bill comes up for consideration.
I hear that we got a new commissioner that has experience in construction and real estate. Would it be fair to say we can invite that person to be on the facilities committee, building committee?
You'll have to take that up with the chair.
Absolutely. We didn't make appointments to that today, but we can certainly put it on the May agenda and make an appointment.
Wonderful.
This is not on the agenda. I can't do it today.
Got it.
But I can do it. And wasn't Commissioner Alley on that?
He was.
Was also had commercial construction
Correct.
experiences.
Correct. Any other questions?
My only comment is that, we have some, probably two commissioners at least, that have a lot of commercial experience, and I would sure draw from that in the future.
That's what we were doing with Alley and Arriaga. And
Just out of curiosity, Madam Chair, where is the building now? I mean, because I'm in the budget committee, and I understand that it was originally.
Commissioner Stevens, if you would put your microphone on, just so everybody can hear you.
Thank you. So where are we on originally it was wanted by this commission to secure one building for the agency. And then next thing I heard, no, it cannot be for just one agency, it has to be more. But is everyone on board on everything? Because we are speaking about things that are not really specific. So can you inform us, please?
Absolutely. So I would happily present or represent because we have new commissioners, kind of a little history of how we got to where we are, and then also what the project is going forward. And I would only ask that that until I have an opportunity to actually sit with the Facilities Commission, it would be, I wouldn't be able to tell you what the path going forward that they've agreed to is. I can only tell you what we've proposed. Okay? But for now.
That's all I'm asking, because I don't even know what it is this commission wants. I mean, we are learning, well, at least I am, from the meeting, and I think that's why we have a question. Thank you.
Okay. So I'm happily I'm happy to give you just a brief synopsis. There is a small parcel of land in the Capitol complex that's adjacent to this building. It's behind the Bob Bullock History Museum. It's called Lot 19. It currently has 80 parking spaces on it, and that's all. It is not part of the Capitol Complex Master Plan Phase 1, 2, or 3. Those are the actual design criteria that have been put in place for specific phases of development of all open and parcels where there's currently where there's currently buildings that will be demolished and redeveloped. Okay, this particular small parcel is not destined. It's not already identified for any particular project in any of those phases. That makes it an opportunity parcel. We have spoken to the Facilities Commission, and they have agreed to work with us to develop a building on that site to meet our needs, and to propose that to leadership through legislation to authorize them to enter into an agreement with us to develop that building for us. Originally, prior to the adoption of the master plan, Capitol Complex Master Plan by legislation, we had a tentative design agreement with them. This is the parcel, this is the size building that should be put on it, all of that stuff. As a part of the master plan, one of the principles that's contained in that plan is that every single parcel must be developed to its maximum economic potential. That made it necessary under the Facilities Commission judgment to develop a building twice as large as they had originally agreed to allow us to develop there. Okay? That requires us, it's twice what we need. And so that requires us to find a partner, if you will, who can use the balance of the building. And so I have approached other agencies about doing that. I have at least two interested parties, subject to authorization by agreement with the Facilities Commission, authorization by the legislature, and then final approval by this commission and of course the other two commissions on the funding parameters. That's where we stand today.
I have a question. So at this point, we're kind of in conceptual phase.
Yes.
Right?
Absolutely.
Yes. Do you have a conceptual budget?
We do.
What is that?
We do. So this is the Facilities Commission actually did the budget based on the second. We actually paid them to do this for us when they said it has to be twice as big.
Payment was authorized by this commission.
Yes, absolutely, to pay them to do this study, and they came up with a budget that was approximately $25 million.
And as you know, in the commercial construction industry, if you start building it now, it's going to be $35 million.
If we start building today.
Because of the cost of material and labor and.
Oh, sure. All that will have to be redone. And in addition to that, it's capital complex, so it needs to be built to 100-year standards, not 50-year typical construction standards. So it's it's around $500 a square foot in essence, right, to build.
And that was reason I brought it up earlier in the meeting. It's going to be building for us, but it's not $25 million. How much was it specifically for just for the TREC?
Originally, it was about $15 million total.
So now we've been instructed that to build building, you got to build a bigger building. My concern is who's going to pay for it, and because right now our clientele are people that pay the fees. And
that's correct.
So we got to be fair to them and not carry the load or take the risk in doing the entire building, or maybe we can do it on a fee for TREC, which I don't think we can or should, because we're all brothers in the same organization. It's state taxes from one pocket to the other. So that's why we need to spend more time talking to the commission on the direction we want to go before you start opening and closing doors on the Texas Facilities Commission.
Well, the Facilities Commission, nothing will happen at the legislature. The Facilities Commission has, there's actually a Capital Complex Oversight Committee that consists of leadership, and the people who report to them is the Facilities Commission. It's not a matter of whether I want to go to Facilities Commission. There is no other path. You have to go through the Facilities Commission.
Is the legislature going to pay for it?
Though all of the financing options will be discussed, and nothing will happen without this. With this, until this agency says yes, we're going to advance. Yeah.
I just want to address something Commissioner Stevens said, and I mean, nothing. We're still, as Commissioner Williams says, very, very much right in the conceptual phase, and I mean, there are a number of questions that the commission needs to make sure are answered before we go down this path. And I mean, namely, is does building a building create value for both the agency, the public, and for license holders? And is the value that is going to be created greater than the cost of the money to license holders, the public, and the commission? So, we're still very much in the conceptual phase. We're exploring options, and Doug has to make that case to all of us. So, don't think that anything has been decided. Quite the opposite. It has not.
Yeah, the original proposal at $15 million, the cost benefit analysis was much easier. Now, with additional parties and additional costs, and the stretching out of the time frame, and the additional layers of oversight that are built into the capital area master plan, capital area complex master plan, all make the cost benefit much more complex. So you're absolutely right, but every one of those decisions will come to this full body for its decision.
And your time and your staff time of trying to complete the building, because as we know, things are going to happen when you start constructing.
Oh, absolutely.
So we need to discuss this further, I would say, and maybe even have a workshop on this. We're going to be spending $25 million of somebody's money, and most from the licensees. We need to answer some stuff.
And that's absolutely true. The additional funds of course, the funding mechanism involves now our partners as well making contributions. And so those are all, we may decide to go forward and one of them may say, no, not at that price. And so we can't advance, right? If that's a necessary condition that you put on the deal and they say no, we can't advance. That's okay, I understand that. Thank you.
It seems to me that you are trying to bring partners in that will decrease the amount of dollars that we would have to put in.
Oh, absolutely.
Yes.
Yeah. I'd love to be able to get back to the cost-benefit analysis that made sense, that convinced us this was the right path to start with, right?
Yeah.
If we get it back to there, that would be good.
Yeah, that's true. Are we done?
That is 23, if there are no additional questions.
Thank you, Mr. Olmixon.
I'm going to sit over here because I have another one to do.
Okay.
Madam Chairman, I have a motion.
Yes.
I move that the Commission ratify the TREC budget reallocated as present.
Okay, is that?
That's 24 is next.
That's
Oh,
not-
sorry.
That's 24.
I was reading the bottom. Move that staff is authorized to do
Hey,
nothing.
wait just a minute. We've got a 23A,
23A.
and
I'll start that.
you're going to do that. Okay.
Well, wait, are we still at number 23?
No, that was just a discussion.
I
We're
see.
not making
That
a
was
motion.
just a discussion.
We have a 23A
23A.
that was added to the agenda.
The agency added an emergency agenda item. That is now 23A.
It was emailed to you.
It was electronically.
It was emailed to you this weekend.
Yes, I got the email, but not the attachment.
I didn't either.
Okay.
All right.
You have to click on it.
No, I clicked on it.
Amended agenda.
Well, it's
So-
not that. It's just a discussion.
Okay.
So
Yes, and it
go
is.
ahead.
It is the discussion regarding possible future action to remove the word realty from new Rule 22 TAC, Section 535.155, subparagraph D, subparagraph 5, regarding advertisements.
So, are you going to say more than that?
I am.
Okay.
I am.
Do it.
So the agency added this emergency agenda item under Section 551.045, subparagraph B, subsection 2 of the Open Meetings Act, due to information that has recently come to our attention regarding a greater adverse impact on license holders with existing team names containing the word realty greater than anticipated when the rule was adopted in November. Since that rule does not go into effect until May, any change to permit the use of realty in a team name, it's currently not allowed under the proposed rule, needs to be discussed as soon as possible to prevent license holders from expending resources and changing their names, changing a market brand unnecessarily. The situation was reasonably unforeseeable because during the rule-making process, the professional association representing over 2/3 of the license holders in the state, supported the change as proposed and adopted. It was only recently, after adoption, but prior to the effective date, that license holders reached out to the agency, to their professional association, and to state government to express concern and to quantify the hardship that this change could potentially cause. So it is open for discussion whether or not the word realty should be removed from the list of terms that would that can be used in a team name. To the chair.
So clarification for me.
I don't think you're on.
Try again.
Yeah.
We can use, in a team name, we can presently use the words group or team. Right?
That's not a change.
Not presently.
That's not a change. Not presently. You can use it.
Under the new rule.
Under the new rule.
Those two words are the only two that are acceptable, and is the present proposal, no?
No, ma'am.
Okay.
So that is not under discussion whether or not a team name should still end in the word team or group. Okay? That's definitional. It's under the new rule. Team names must end in team or group. Okay? There's a section of the rule that specifically says that team names, it would be misleading if a team name had terms that imply that the team is offering brokerage services independent from its sponsoring broker. And then it gives a list of the words that would tend to give that would be misleading. So, including but not limited to brokerage, company, associates, and realty. So what's under discussion is simply removing the word realty from that list.
So that in addition to the words team and group, you could also use, if you were a team person, you could also use the word realty.
You can use as many other words as you want. It still has to end in team or group. So I want to just make sure that
so it could
you're
be
not
realty.
saying team, group, or realty.
It could be realty team,
Correct.
realty group.
Correct.
That's what I was just trying to.
That's right.
It could be
Could be
Jan's.
Miller
Yeah.
Realty Team.
Got it.
Today, or excuse me, on May the 15th, that would not be allowed.
Right. And so they're
So this
wanting
discussion is there are apparently quite a few who have realty in their team name already and would like to continue to use it. And when the rule as currently adopted goes into effect, they would no longer be compliant. So the discussion is, should you remove the word realty from the list of prohibited terms?
Mr. Arriaga.
Emergency items make me nervous, Counselor, because I did not have a chance to look at, didn't have a chance to talk in my office or back home. But somehow, some way, someone decided it's not going to be done. And one way we can get into trouble is someone said, look, if something smells, follow the money. So I'm concerned why overnight, all of a sudden, we decided, let's get this done. And I can see that's going to cost someone money if we leave it there. So I'm just worried that we might be moving too fast for our own good.
Well, nothing will be done here today other than this is a discussion only. It's not an action item. Okay? And so I'm happy to answer any questions about how it came up as a discussion item.
One question. Anybody on this commission bring this a concern to you about the name realty?
Yes.
Okay, who was it?
So the information came from members of our license holders, came from members of the legislature, okay, for whose constituents complained to them, and then we had this discussion, and we were authorized by the chair to put this as a emergency discussion item only.
You can see my concern.
That's all we can do, and that's all
Right.
we could do.
You can see my concern that sometimes there's some influence that can go certain directions. If I would have called you and said, look, let's do this because it's going to impact commercial, I might have some undesirable influence going on. So just for the record, emergency items make me nervous, especially if it comes from someone here that has to be transparent and be able to say, I didn't hear it, my phone never rang. I never got an email saying, hey, you got a problem. So somehow, there might be some leverage going on.
Well, so it didn't originate. It didn't come like, no commissioner called me and said,
it didn't come
hey,
from the commission.
This is a problem.
That was the question I asked. Did it come from a commissioner?
No, it was authorized by the chair to be placed on, but it came from license holders.
And the legislature.
Right, and constituents of the legislature who said
The legislator called and said, remove it.
Well, it's far more extensive than that.
Got it.
Far more extensive than that.
Well, can we get a sense of the
Absolutely.
extent? I mean, that's
Certainly.
my question. How
No,
many
no,
people
certainly.
are calling? I mean, is
Well,
it
it
a
was
big deal? Like,
so the sponsor of the bill called us and essentially said, I don't believe that's what we intended in the bill.
And who's that?
Senator Hancock. And there's not a direct connection between the bill. It's an indirect connection, but there were the senator. I met with the senator's staff. Several of us met with senators and his staff, and he made it very clear that in fact he had heard from multiple parties, including other members of the legislature who had heard from their constituents, and because in the explanation of the advertising rule that was on our website, it starts with changes to the advertising that were made in the last legislative session. And then it continues on with all the 20 months that we've been negotiating with our stakeholders and discussing this in the last time we did strategic planning as well, all the work that has gone into. Well, the connection between the two is indirect, but it was direct enough for him as looking at it to say, I don't see how this, one, stems from my bill, and secondly, I don't see how it actually accomplishes what you're trying to accomplish in terms of the direct implication that somehow the term realty all by itself would imply this operating independently from a broker, and lastly, that even if it did, it's cured by adding the word team or group at the end.
The reason
that
I bring this
makes
up,
you know it's subordinate to a broker.
the reason I'm so passionate is because we decided to make some changes and upset a lot of people. Okay, and now we put up with it. Now all of a sudden we're going to change it because we want to change it.
No, that we're discussing that. That's what we're doing, is discussing that.
Correct.
This is not a proposal to change it. It's a proposal to discuss it, because only you can change it.
Well, and be clear
Not today.
that Senate Bill 2212 has actually no relevance to the team name stuff. The stuff that 2212 changed is other parts of the proposal that are not being brought up. It's confusion at a very high level.
And we created it.
Maybe.
Madam Chair, if I may.
Maybe we did. Yes.
So that perhaps we can learn from this that it's not so much the quantity of time that we spend on any given project. That I read this, I have never attended an Arello meeting, but when I first read all the information, I brought this up during a commission meeting, and I'm going to bring it up again for the sake of especially the new commissioners and the agency. And perhaps we can learn from this experience that we need to be consistent when we present anything. Is the things that we need to think about is what is the worst thing that could happen? Can we live with that? And is this necessary? And we are not going through either of these things before we even present anything. So the time that we spend on any given thing is not indicative of the quality to prevent this from happening. And one of the things that I brought up whenever we were talking is the public asked, and that was during the last TREC meeting, that we be clear and simple. And if there is confusion, even within the commissioners who are so familiar, especially the ones that practice real estate, and how can we expect clarity from the public? And I think that we need to really learn from this and prevent this from happening. And I'm going to make a recommendation that from this point on anything that we have proposed, that especially if it's an emergency, that it be stated on the email, this is an emergency item, and that it be included, and just to be on the safe side, just so that we can actually read it, because when we hear about it and when we see it in context, there's no way that I'm prepared to even vote on something that it is part of a rule that I have not even read. But for the future, so that we can learn from it, is that I'm going to ask that on anything that we are proposed, that we please include the authority where we're getting it, and please quote it so that each commissioner can make up their own mind as to the intent, because that's our job, and so that we can prevent this from happening again. Thank you.
So the discussion is around removing a barrier, adding flexibility, clarifying a rule adopted by this commission that had an unintended greater impact than we anticipated, all of us together. And I use the time frame not to talk about the quality of it, but the extent, the number of times we met with large groups of stakeholders, thousands of licensees, and no one raised the issue. So that's the unanticipated. So it's like we get down to 3 months before the rule's going to go into effect, and all of a sudden it's like, oh, that's what you meant? Well, that's a problem. And there's enough of that it was worthy of discussion today. What steps might be taken with respect to that?
Okay.
I wonder if you've gone to our State Association of Realtors, have you gone to the educators, and have we asked them the same question?
Yes.
Yes, ma'am. In fact, they were at the table in every single negotiation on this rule.
On what we're discussing right now.
Yes,
correct?
and
so they heard it before we did, I guess, huh?
Oh, no. TAR, all the stakeholders were at the table when the whole thing was created. No one has been engaged in this emergency until
that's my question.
about the last 36 hours.
Okay, I started to say that was my question.
All happened real fast. And as you recall, the chairman of the Texas Association of Realtors, well, at that time she was chairman-elect, stood before us at our meeting in November and said all 100 and however many thousand members we have support this completely. And we have a letter, I have it with me, from the trade association supporting both of these rules. Neither the trade association nor the regulatory body could foresee the outcry from teams who were going to have to spend money taking the word realty out of a name that they had used for a long, long time, or that these people would call all of their legislators and tune them up.
Right. That's my point right there, because can we go back to the educators? Can we go back to the state association and ask them about this?
We got the state association here, and they've got a comment.
Oh, good.
To make.
Good.
Okay, but first do you want to let TAR go first? Abby Lee, come forward.
Thank you, Commissioners. I will be brief. My name is Abby Lee. I'm an attorney with the Texas Association of Realtors. And regarding item 23A of the agenda, the Texas Association of Realtors does support the Commission's reconsidering the use of the term realty in a team name. So if there's any questions, I'm happy to answer that. But otherwise, thank you for your time.
Yeah, just so we get some understanding, I mean, how many approximately of these teams are there out there? I mean, this isn't just to address Commissioner Arriaga's concern that it's, a small insular problem that's maybe being pushed from, through undue influence or something like that. I mean, are there a lot of people use realty in their name?
I actually heard Mr. Olmekson talk about this on Saturday, and it's a little difficult from my understanding to know exactly how many teams there are, but I believe he said in the 800s. He got it. Okay.
Great. Would love to hear it.
Counselor, when did you first realize it's going to be a problem?
I wasn't directly involved in those conversations, but I believe it's been in the last 24, 36 hours.
Who was directly involved?
Our general counsel, a few of our lobbyists in our governmental affairs department, our CEO, Travis Kessler.
So someone of influence called TAR and said, hey, guys, we got to stop this?
Yes,
Especially realty, not real estate.
that's right.
Just realty.
Right.
You can see, I'm sure it's a whole bunch of other names we could have also excluded or included, but they've not had the chance to do that. So we are making rules for certain specific areas, and I don't feel comfortable with that. I don't feel comfortable at all with most of the sign changes anyway, but that's just what I'm finding out. Thank you so much.
Thank you.
Madam Chair, no.
For her?
Thank you.
No.
Thank you. Madam Chair, I do have a comment.
Okay.
That I attended the TREC tour about 2 years ago, and it was mentioned by several people that cost was a concern. And my concern is that this commission is here to make sure that the rules are applied evenly and fairly to everyone. And this is a concern, because if there's a group that has more pool, well, then we're playing favorites, and that's not what we're doing. And we need to correct the situation and not make it just for them, but let's correct that, but also let's correct everything. Everyone, a lot of people, everyone that is in real estate, as to the rules, is probably going to have to make new signs. Or if we change it for one, let's change it for everyone.
So this is the only, so just to address that, this is the only issue that has come, it's the issue that has come in the greatest number and with the greatest sense of urgency and force behind it, if you will. In other words, there's not a whole bunch of people lined up complaining about any other part of the advertising rule that's proposed. Just this.
Madam Chair.
Yeah.
Here's the thing, is that there are a lot of people out there doing their job, and they don't have the time, the money, or the effort, or they should not have to be here. So I speak for them, just to make sure that you don't have to have the pool. You have to just be out there doing the right thing and hope that you can get represented, so that it's not just those people that have access to high levels that they can get things done. That's our job. Thank you.
Well, let me just say, 2 years ago on the listening tour, it was a completely different proposal that would require all brokers to have had to spend money on signage and advertising. And these changes are very limited, apparently, in who it affects. So instead of 180,000 people, it's 800 and something.
So the number, this is the maximum impact number, okay? It's still substantial, but today, companies with, let me make sure that we get this correct. There's about 6,000 brokerages who use the word realty in their name. None of that has to change.
None of that changes.
Okay? Now, today, brokers register team names with us as a broker DBA, okay? And so there's 3 categories. Business entity brokers with realty in an alternate name, 1,054. Individual brokers with realty in an alternate name, 848. Sales agents with realty in a registered alternate name, 24. Add all those together, it's 1,926. Potentially, if every one of those is a DBA for a team. They're not all, but if everyone was, it would be just under 2,000.
I have a question, Counselor.
Yes.
Initially, we did not want to use realty, or we use group and teams to make sure that the public does not perceive that team is the broker of record. Is that correct?
That's correct.
So now we decide that maybe realty can be that bad.
No, that's not right.
Well,
That's not exactly right.
The public then all of a sudden is not going to be misled by putting it back in?
So I'll happily tell you what my perception on this is, because I think it has had some influence in this regard, is that if you went to Black's Law Dictionary and you looked up realty, you would say it's equal to real estate. It's just a shortened version of the term real estate. Okay, real estate. If you are a developer, you have real estate in your name potentially. If you are an investment company, you can be a real estate investment company, home builder, lots of different things, or you could be a broker. Okay? It is almost without exception that if you use the term realty in your name, that you're engaged in brokerage activity. Okay? That's just, the market has developed that way. And I give a lot of credit to the Association of Realtors for keeping that correlation. Realty all by itself, if you use that term, people would think brokerage activity. If you put it in a team name, and this is, I think, one of the things to be considered here, if it ends in team, if the name of the team ends in team or group, then what appears before it is mitigated if we do a really good job of educating consumers that there's a broker on every advertisement. There's a broker's name appears, and that's the ultimate contracting responsible party. That's who has to provide the services. That's the party you're going to contract with for services, for professional services. If another name appears there, if it ends in team or group, it's subordinate to that broker. Any other name that appears in the ad is subordinate to the broker.
So it's realty team, realty group. The public is not going to be misled. Is that correct?
That's the concession that we're being asked to consider. If you leave the word realty in there, is that will they just see that as real estate as opposed to brokerage?
Will we be accused of splitting hairs now?
I can never be accused of splitting hairs.
Nor I.
I don't have any.
Mr. Elmixson, what was the objection?
I'm sorry?
What was the objection that was given to the commission for the commission to come up to an emergency meeting when so many things are being done we find out sometimes at the meetings?
The unanticipated, the extent of the impact.
And what is that?
The cost to fix all those people who have realty in their team, these 2,000 potential people who have realty in their team name already. That's one issue.
However, the real problem was because this is already final, if we were to go to May, and between now and May, this ugly bear is still raising its head, and you guys all got all these calls, and people wanted to take away the word realty. Meanwhile, all of these people who have realty are spending money to change it. So if we're going to have the idea that we might want to change it, we need to discuss it today so that we can say we're discussing it again, and people don't change it only to find out in May that you've gotten 100 calls and we want to put it back on the agenda and you've got 750 people that have changed it.
Madam Chair, I believe we've discussed it.
Okay. So I don't know what you think. I mean, I really don't.
Madam Chairman.
Okay.
I would just like to say that I'm wholeheartedly in favor of making this change, and I think it makes sense and is logical, and that the public is protected, because I think that the mitigating factors of having team and group, right, as well as having, as you say, Doug, it being subordinate to the broker, and so long as the broker's name is always in the advertisement, I mean, team and group makes it very clear which is which is the broker and which is the team and which is the group. So I think it's a logical rule, and when we go forward with it down the road, I will be in favor of it.
Okay, so if we kind of get a consensus, or
Yeah, so if I may,
then we
Madam
could put
Chair,
it on the
just-
listening tour and we could hear it.
Just to how the process has to work. This rule is adopted, and it's not effective till May 15th. So we can't actually, as a body, take any action on it until May. At the May meeting, you could actually propose, because it wouldn't be an emergency rule, it would just be a regular proposal. You could propose an amendment to Rule 155, whereby you would just take out the word realty. That would be it, one simple change. but it would have a big impact, and then that could be proposed on May 16th. The rule would go into effect May 15th, be proposed May 16th, but it wouldn't take effect until it was adopted at the August meeting, okay? So what I guess what we're really discussing here, if that's the way that people are thinking they need to go, is we need to let the license holders know so they don't change it in anticipated of the May 15th rule going into effect and then realize they could change it back. Because for some of these folks, the complaint is not just the cost, but they've established their identity with that name. And they don't object to putting group or team on the end. It's just, I've been Lewis Realty, and I'm okay being Lewis Realty Group or Lewis Realty Team, but if I have to change it to Lewis Real Estate Team, I kind of have a marketing brand. So that was the argument there. But I think, to be fair, and the reason this was put on as an emergency discussion item is because if we wait to May to make a decision about instructing staff to not enforce if they've got realty in the name, or to allow them to accept realty in a team name in the meantime, or at very least just not enforce against it until a final decision is made, then it's going to be a disservice if you do decide to change it in the future.
Would it open a Pandora's door for other people saying, how about this term?
I don't think so, because the term, if you look at subsection D, and I'll read it to you. Well, Doug already read it to you. It's just an example of what's in a team name that would imply that they're offering brokerage service independently. Obviously, brokerage or company, that clearly implies that. But if realty is not at the end of a name, but sandwiched before, then maybe that's not as strong a case. And that's what people are saying. They don't see a big difference between realty and real estate if it's not at the end of their name.
Did we determine how many people this changes on signs is going to impact, period? Just a complete change other than just realty? We don't
register teams, so
Yet.
everyone, right, not yet, currently. So I can't go back and say we have 7,000 registered teams that don't have team or group at the end of their name already, and so they're going to have to come up with
Not
new,
so much in teams.
I don't know that.
But in brokerage, period.
Brokers don't have to change anything.
Right. But somewhere, somehow, some people got to
Only
change
teams.
signs.
Oh, just teams.
Only teams. And it's in advertisement. Obviously, the electronic stuff is easier, but if you have it on hard, durable, especially signs, that's the big deal.
Madam Chair, what are you really needing from us today?
Well, General Counsel mocked up something that's,
Okay.
Commissioner Miller's going to read.
I move that staff is instructed to publicize the commission, that the commission intends to propose a rule amendment to 535.155D5 to delete the prohibition against using the word realty in a team name at their May meeting. Further, staff should accept registration of team names that include the word realty and not discipline any license holder that advertises a team name that includes the word realty.
I second the motion.
Was that what you wanted to say, Bob Baker? Okay. So I have a motion, and I have two other people that wanted to speak. So do you consider yourself spoken? You're good. And Rebecca Ray? What'd you say? She's good. Okay. Any other discussion?
Are there any conflicts with people on the commission that have the term realty in one of their teams?
I have no idea.
I don't either.
I don't.
I have no idea. And I'm not going to vote anyway. So. So, all in favor say aye.
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 And opposed, no. Motion carries. Dang. 24.
Okay, I promise this is going to be a lot easier. We've got before you the budget amendment 24. When I mentioned earlier during the budget status report that we were simply going to ratify the budget status report, which moves the allocation, which we discussed in the last meeting. So the September budget status report is amended to present at the November commission meeting. It's been modified to reflect the allocation of fees between TREC and TALCB for the State Office of Administrative Hearings. The original budget, which was approved by the commission in August, was created before the 2017 actual usage was received from SOA. The expenditure category professional fees and services budget was increased by $24,100. This agenda item appears for ratification before the commission.
Commissioner Westcott, weren't you trying to do this a while ago? Okay.
Madam Chair, I move that the commission ratify the TREC budget reallocation as presented.
Second.
I have a motion and a second. Is there any discussion? All in favor say aye.
Aye.
And opposed, no. Motion carries. Agenda item 25.
Okay, and this is annually we bring before you the investment policy. And you'll note in your materials, and this is on page 297, you've got a clean copy, and behind it you've got a redlined copy. And behind that, the redlined copy just shows you that we've changed a few words just to clarify some things. And then we've added in training because we are required by the Public Funds Investment Act to have that training, and we thought it would be simpler to have it all in one place.
Do I have a motion?
I move that the commission approve the TREC investment policy as presented.
Second.
A motion and a second. Is there any discussion? All in favor say aye.
Aye.
And opposed, no. Carries. Agenda item 27.
26. 26?
6. Oh, 6. I thought I just skipped 6.
Madam Chair and Commissioners, you have on the dais, you were presented with the agency strategic planning tour announcement. This is on our website. So it is, I was asked earlier whether or not the locations could be added to or why certain places were left out. And so this is, with respect to that, these are all of the places that we intend to go and have meetings this year in person. And then you'll note there's 2 additional online sessions on March the 15th and again on March the 27th. The only other thing that I would add is we are currently in negotiations with El Paso, who we haven't been there for 4 years, and so we'd like to go back there again, and they're trying to work out an acceptable date and time for us to travel out there as well. But I'm happy to answer any questions that you have about the strategic plan tour. One other thing that I wanted to bring to your attention is because we're undergoing sunset this year as well, and that will involve some extensive time both in the summer and the fall, we're going to try, I've asked the staff, to try to have our strategic plan ready for your action at the May meeting. Normally you might only see a draft and then delegate the completion of it over the summer. It's due by the end of, or by September 1. We're going to try to get it all done prior to your May meeting.
Okay. I need a motion.
Madam Chair, we move that the commission approve the strategic plan calendar and issue as presented.
Motion to have a second?
Second.
Have a motion and a second. Let me just encourage each of you to attend those that are near you and hear what the people are saying. So, all in favor say aye.
Aye.
Any opposed, no. Motion carries. Let me try number 27 again.
Madam Chair, this is discussion and possible action to approve new or changes to existing TREC forms. And there are, I'm going to take them in 2 parts. The first 2, A and B,
Staff is asking the commission to ratify the use of these two new forms, which are needed to implement the name registration provisions in new Rule 535-154, and it's splitting out assumed business names separate from team names. And then the second four forms, have been revised to clarify that the commission requires disclosure of all prior criminal history, even if it may have been reported in a prior application with TREC. This is something we see over and over again, and you can see that the clarification has been made on each of these forms and the background history form to very specifically say that you have to submit documentations even if you have submitted these documents with a previous TREC form or application.
Okay. So I would seek a motion on the three new forms, A, B, and C. Notice
A and B first.
A and B only. A notice of team name and notice of assumed name on agenda item 27, A and B. It's the first motion on page 307.
I move that the commission approve new or changes to TREC forms listed under A and B as presented.
Motion to have second.
Second.
All in favor, say aye.
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 Opposed, no. Motion carries. Now, I would seek a motion on forms C through F, which clarify that we always want to know about somebody's criminal history, even if we might have known before.
Move that the commission approve changes to TREC forms listed under C through F as presented.
Second.
A motion and a second. Any discussion? All in favor, say aye.
Aye.
Opposed, no. Agenda item 28. Anybody have anything for the future? Okay. I guess our next meeting is scheduled on the calendar for May the 7th at 10 a.m. and the following one's August the 13th. Is everybody clear on that? Everybody good? Yeah. Go ahead. No? Okay. We are adjourned at 2:20.